calling the meeting of Child and Family Law to order. First up, we have House Bill 206 and 204. Do we have the prime sponsor here? Oh, Representative Spillane. Good morning.
Good morning. Thank you, Madam Chair, and members of the committee. I spoke to Chairman Abbas earlier, so I know he's on his way. I'm introducing to the Senate House Bill 204, which passed the House with bipartisan support. And this bill, interestingly enough, passed the House and the Senate last year, last term. It went through Judiciary in the Senate last term, and the chairman of Judiciary made some small amendments to it and sent it back to the House for concurrence, but because of some disputes within the caucus that were not even related to this bill, they decided to kill a few bills just out of spite, and that was killed in the House, and there was a non-concur motion. So I bring it back to you with the same language that the chairman of your Judiciary Committee put into it last year with the amendment. This is exactly how you passed it last year, and it's fairly simple. In essence, it's seeking to fix a problem where occasionally reports get made up to the federal government that somebody's delinquent in their child support when they're not actually meeting that threshold. I had that happen to me personally. I was denied a passport that I needed to be able to travel for work because I was told I was delinquent, but I have my wages garnished for my child support, so how the heck could it have happened? I get paid every 2 weeks. The Bureau of Child Support Services has a weekly payment schedule. My work remitted payments every 2 weeks based on the garnishment amount, but it would misalign through the year. And so there were months in the year that I would be showing myself delinquent by a small percentage. And then by the end of the year, things caught up again because they take the total that you're supposed to do on a weekly basis, add it up and divide it by how many pay periods I get. So I know this problem would be aggravated even further by somebody who's only paid monthly, or if they're in the situation where they're only paid every 6 months, or once a year even. Anybody who's not paid on a weekly basis is going to find themselves misaligned because their company's not remitting payments on a weekly basis. So anyway, with the help of the Senate last time, the language was agreed upon that we will just add some new language to this that says, the department shall maintain an automated system of reporting child support arrearages that complies with the federal guidelines on child support delinquency and shall not report as delinquent any arrearage that does not meet the applicable federal threshold. The system shall also report the requesting agency the dollar amount of the arrearage if the account is delinquent. And the reason that part is important is because I have heard from Bureau of Child Support in New Hampshire that they say they do report the amount, but when I was trying to resolve my own situation and talking to the State Department to get my passport, they said, all we see is that you're either in compliance or out of compliance, and we don't even know by how much because we don't have a dollar amount. So they couldn't see, oh, it's off by $25. That's not really delinquent. We'll let him have his passport. So I think that by having that dollar amount, it will show true whether it's a true delinquency situation or whether it is just an error in the rounding math. And so that's why I bring this back to you again. As I said, this is the language that was passed through the Senate with the amendment from the chairman of Judiciary last year, and I hope you'll support it.
Thank you. Any questions from the committee? Senator Long.
Thank you, Madam Chair. Thank you, Representative. So the federal threshold is $2,500. So if I'm in arrearage $2,500, I pay $2,400. I'm still in arrearage for $100. What you're saying is the system will report to the requested agency that I'm still in arrearage, correct?
And I would hope it would update to say it's $100 now at this point, but
Okay.
yes.
Okay, so in essence, what you're asking is that the Division of Child Payment would let them know that not only are you in arrearage, but it's $100 arrearage.
Yeah,
So
I
that they
think
don't go after you for
I think
your
in general,
license. or
correct. I think in general, I think an update to their system that automatically reports is probably what's in order, just to make sure it's functioning correctly and it's reporting at the right times. One of the other issues that we run into that is not addressed by this bill, but I think they could address in the system at the same time, is that we found out that while they report to the federal government that you are in arrearage and have met the threshold and now you're considered in arrearage, when you clear that up, they don't send anything to say he's not in arrearage anymore. It's up to me to call. And where in my situation I was garnished, I had no idea that I could possibly be behind or that I had ever been reported. I don't know if a letter was sent that I never got, but I was never told that I was in arrearage until I got the denial of the passport. And when I called them, they said, well, it's because you're showing you're in an arrearage. And when I called up to find out how much, it was a less than $100 amount that I was in arrearage. And it was, when I looked at the payments coming from my work, I realized it was just a misalignment of the payments. And in the next month, they'd be caught up. But in order to get my passport facilitated quickly, I had to actually make a credit card payment to the division here in the state. And the guy was very helpful. He said, give me 24 hours to make sure it's processed, then call the federal government, have them ping you again. And when they ping New Hampshire, it'll say it's clear, and then they'll process your passport. It was a lot of work to go through. I'm hoping that we can clear it up so it doesn't become an issue for other people in the future. But I think that the state system probably just needs an update.
Okay, thank you.
Thank you.
The Honorable Betty Gay. Good to see you.
It's good to be here. I love that in New Hampshire that we do have access. And it's also nice to know all three of you, so that makes it a little less scary. I'm here to support this bill. It's already been very well explained, and I'll just add another thing, that I'm glad that we do track whether people are paying on time. So this is open and shut. We need to pass this bill. But I'll add that I was at a hearing where the person receiving child support had to go through a game with the person paying it because, I'll just have to use pronouns, because he played a game. And he never paid child support until a week before whatever hearing she scheduled, because she'd been waiting for months to be paid. So I'm really glad that we have the system. And I think, this just makes it fair on both ends. Thank you.
Matthew Hayes.
Good morning. Attorney Matthew Hayes, Bureau of Child Support Services. I'm a staff attorney with the Bureau, and I also serve as their legislative liaison. The Bureau does not have opposition. It's neutral with this bill. The Bureau's position is that it already does have a certified automated child support system. It's compliant with what the federal government, how it outlines and how it should work. And we also were testifying on this bill last year as well, and I know that we did work with Senator Carson with the amendment. So I'm here to answer any questions that this committee may have, but as I stated, the Bureau is neutral.
Thank you for your testimony. If I may inquire, you did hear the testimony of the representative who introduced the bill?
I did.
Now, based on just what his explanation was, what exactly went wrong in the process where he, obviously the federal government was saying he was delinquent? Like, what was the breakdown there? At least I understand maybe your guess or assumption.
Well, thank you for the question, Senator or Mr. Chairman. As you kind of alluded to, I really can't get into any person's case specifically, but generally speaking, I think that how the system works is once you meet that threshold of $2,500, the passport doesn't get, I guess, reactivated, let's say, until you hit zero. Or if somebody calls in, works with the case officer, and then they can take a case-by-case basis and sort of report it in a different way to the federal government. But the federal government won't, so there's a Federal Child Support Bureau, I guess, which is part of the U.S. Department of Health and Human Services. That's who our system reports to, and it's their system. And then they give whatever information they give to the Department of State. So the Department of State wouldn't necessarily know what the arrearage is. They just would know what they're getting told by the system. I'm not necessarily sure. I'm not aware of any reason why our system wouldn't be working correctly. I'm not aware of any sort of glitch or anything that would cause systematic errors of this nature. I think it's just a matter of what the balance is when it gets reported each month. And it's certainly possible that a person is complying with their court order, but they have some arrearage. It doesn't mean that they weren't complying with their court order. It could just mean the way their arrearage is accruing, or the way their order's accruing with how their payments line up. They might have, a small balance when it gets reported, but they're otherwise compliant. That would be a good candidate, if I may, for reaching out to the case officer and the case officer saying, okay, yeah, I see what's going on here. Let's take care of that. I can't imagine that wouldn't happen.
Thank you. And if I can ask a follow-up, you say arrearage, is that $2,500 factoring in interest and penalties on top of it, or is it just the child support amount?
It's just child support. I know different states do it different ways. New Hampshire, there's no interest we don't do interest on the child support. It's just straight accruals.
Thank you. Senator Long?
Thank you, Mr. Chairman. So as far as what's added from line 7 to 10, that's already being done. It's being put in the statute. That's fine. Now, when you electronically get it, looking for information from the requesting agency. For example, if I'm $2,500 behind, I get reported. I pay $2,400. When the feds request an update, do you tell them how much arrearage I'm in? Right now, I'd be in arrearage of $100. Or do you just electronically let them know that I'm in arrearage?
That's my understanding, and I'm not on the tech side of the Bureau, but it's my understanding that sort of like a monthly reconciliation in a way, sort of, there's a certain point in the month where if a case in New Hampshire's already met a threshold, then they're basically on the radar at that point. Every month, the system reports to the Fed system basically an accounting of what's going on with the cases. So yeah, they are told as part of a batching process what the balances are. And I think you sort of pointed out, if it's not zero, then it'll stay the same on their end. Even though it's lower than 2,500.
Right. Follow up, if I may. The requesting agency, so the system reports to them, but it doesn't give a specific amount?
It should, it will give it a specific amount.
It will give a specific amount. So line 11 and 12 doesn't appear that the child support division would have an issue with that.
No.
Okay, great.
If I may just sort of follow, there's not a case officer looking at a case and calling the federal government. It has to be automated. There's thousands of cases.
Okay.
So.
Okay, you understand what the issue is. If I'm $2,500, if I'm $2,600 behind on child payment, I pay $2,500. The system's speaking to each other. I'd still be in arrearage of $100, and that could have my passport not being up because I'm in arrearage. I'm not $2,500 in arrearage, but they don't know that. The fact that they would know that, then my passport wouldn't be, if I'm getting an IRS check, they wouldn't be pulling 2,500 out of my IRS check because they would see that I'm at $100 in arrearage.
They would not probably with the they won't do anything with they won't change the passport process unless it was zero. So if you happen to be zero on the day that they reported it, then it would automatically come off.
Okay, thank you.
Thank you, Mr. Chair. Thank you for taking my question. You had mentioned that you worked with Senator Carson on an amendment last year. Is that language in this bill?
Yes.
Okay, thank you.
Seeing no questions, thank you for your testimony.
Thank you.
Are there any members of the public who wish to testify that have not testified already? Representative. Good to see you as well. And if I may, I can just put your name on here if you don't mind.
It was on the second sheet.
There's a second sheet.
Yes, sir.
Oh.
Thank you, Senators. Thank you, Mr. Chairman. I'm Representative Deborah DeSimone. I represent Rockingham District 18, Atkinson. Last year and for a while before that, we heard testimony on this bill. The prime sponsor asked me to co-sponsor this bill, letting me know what his story was, but then I asked House Committee Services to provide the Children and Family Law Committee with the statistical information concerning how many parents suffer the consequences of underreporting. When I say underreporting, it's not that the child support agency isn't doing their job. They have a reporting system that doesn't allow them to include specific dollar amounts. It only allows them to report according to what they say, what the federal guidelines are. The federal guidelines are that if you're $2,500 or more in arrears, you will be penalized by not being able to get a passport. You may have your income tax returns garnished, so forth and so on. But what the difficulty with the department is they don't have certain capabilities. And once you are reported, they don't have the capability of including the dollar amount, which is one question that the senator asked. And they really don't have much of a capability until it gets to zero to take you off the list. Well, according to the guidelines of the federal government, once it gets under $2,500, you should be off the list and penalized no more. This issue with the reporting system is not that the department isn't doing their job. They are working hard. They are trying to do their job. This bill will allow them to do their job better. That's what this bill is all about. There are thousands of men and women who are paying child support who fall into the same category as the sponsor of this bill. We need to help the department be able to do their job better than what they're able to at this point.
No questions? Thank you for your testimony.
Thank you.
Are there any members of the public present who wish to testify that have not testified already? Seeing none, we'll now close the public hearing on Senate Bill 204. At this time, we'll now open the public hearing on House Bill 213. And here to introduce the bill is the sponsor, Representative Spillane.
Thank you, Mr. Chairman, members of the committee. I am still Representative James Spillane from Rockingham 2 and Chairman of the Fish and Game Committee in the House. This bill as well was passed through the House last term. It's a simple fix. I don't understand why it met some resistance on the Senate side last term. I'm hoping that we'll get a little less of that this time. We have, under our current law, the ability for people to not garnish wages as a default. Our system is set up so that when there's child support, the default is people automatically have their wages garnished. Whether or not they have a payment history of being delinquent or anything, it's just the automatic way the state handles it. But there's a section in that bit of the law that talks about that says that if both parties agree, they can make their own payment schedule and own payment plan and methods. They're not told that, though, by the court. So this bill seeks to require that during those final hearings of the divorce, the judge shall inform people that they have that right and provide them, potentially as part of the Uniform Child Support Guidelines, a form that says, specifically on the form, the details of when garnishment of wages will become mandatory, which include things like if there's a protective order in place, you shouldn't be allowed to make your own payment agreements because you're not supposed to be talking to each other. If you're, one of the suggestions I had that's not actually in the bill was that, obviously if somebody's living out of state, it'd be harder for them to have those payment things and collect if they go into delinquency. So it might be better if people who have one party living out of state don't make these agreements. But in essence, or if the person's actually already in arrearage with other child support instances, it probably wouldn't be appropriate for them to go into an agreement to make the child support outside of garnishment. But there's a lot of instances where it's appropriate for the two parties who get along perfectly fine for the payment situation to continue making the payments on their own. And I myself was not told that I had this right. My wages were garnished automatically, and when my son wanted to attend summer camp and my ex-wife asked me, could you pay a couple of months in advance so I can put the down payment on the summer camp? And I said, sure, let me just check with the Bureau of Child Support Services because I'll be paying you directly instead of paying it through them. They said, we can't, if you pay her directly, we have no record of it and we can't do it. I said, well, can I pay you extra up front? They said they had no ability to actually handle a prepayment of a higher amount, that the money that was overpayment would get returned to me eventually, but that it wouldn't end up going back to her. If we had stayed on a situation where I continued to pay her directly, which is what we had been doing before the case was finalized, I would have been able to just give her the money and it would have been much easier. So in essence, the form should contain when will it be a mandatory garnishment? When can you no longer have this agreement between yourselves? It will allow them to put in writing for the court how they're going to make their payments, what the plan is going to be, and what the payment method will be. It will inform the payer that it's their job to keep their records because the state no longer will have a direct record. So they need to keep their receipts and their records in case there's a dispute that comes up and they need to prove that they were not delinquent. And it will inform the payee how they should go about reporting the missing payment so that all of that information is a record of theirs in their final divorce papers to be able to be referred to. And it's as simple as that. The committee on the House side did ask that we pull a fiscal note because they thought it might cost some money to develop that form. The fiscal note came back with a $0 amount because apparently we have parts of the state that make forms every day, and it's considered part of the regular budget that form making is included. And with that, that's all I have. I can answer any questions if you have them.
Senator Long?
Thank you, Mr. Chairman. Thank you, Representative. So in essence, the court has, if the two parties agree to an arrangement, that becomes in effect. The court can't say, I'm not going to accept this agreement, and somebody's going to be a payer and somebody's going to be the payee.
Under current law, the way it's written into the garnishment, it says wages shall be garnished unless both parties agree to an alternate method of payment. And so it would have to be an agreement of both parties, and it would have to be something that they've already decided how they're going to do the payments. The law does, under the garnishment, automatically allow the court to start garnishing if they fall into a delinquent state. And and in other situations. So I assume that the court would have the leeway if somebody was a serial delinquent payer to say, well, you can't, I appreciate that you want to have this agreement, but the payer has been delinquent consistently for several years with another case and is in garnishment already, and we won't let them go that route.
Okay, thank you.
Thank you, Representative.
Thank you.
This time the chair recognizes the Honorable Betty Gay.
Thank you for taking my testimony. Again, bill has been well explained, and I will just mention that this is really good that it allows people to, well, it requires people to be told that this is an option. I would even ask that the form that's named be added to line 5, because unless both parties come up to an agreement under another arraignment, as testified by, as evidenced by the signature, so that nobody can later come and say, well, I didn't know. That way they can choose either thing they want. Yeah, I would make the form so that you sign whether you wanted to, well, it says right here, allowing for both parties to detail their preferred form of payment arrangement, and that would be by garnishment or by private pay. So I think this is a good bill, and I would just clarify with 4 more words. So, thank you.
Thank you. Any members of the public wish to testify? Representative.
Thank you again, Honorable Committee. Again, my name is Deborah DeSimone. I represent Rockingham, District 18, Atkinson. I'm here to testify, and I co-sponsored this bill because, again, it really works with Child Support Agency. Child Support Agency is inundated with garnishment of wages and how to collect them and how to disperse them. In many, many, many cases that it's unnecessary. They could not, when I asked, they could not give me a total amount of how many of the residents in this state are having their wages garnished and would not have to have their wages garnished had they been able to make payment on their own. And I guess that would be an insurmountable job for them to be able to do. However, I think that most parents, and I honestly believe that most parents want to support their children. For the few that, for whatever their reasons, cannot or will not, I really think that it would decrease the workload of the Child Support Agency if this bill were to pass and give most of the good parents the opportunity to pay on their own.
Thank you, Representative.
Thank you.
Any members of the public who wish to testify that have not testified already?
If I may, Mr. Chairman, I just wanted to point out a typo that was found by the attorney so that you guys are aware of it.
Sure.
Line 5, the word arraignment should be arrangement. And I would appreciate it if the committee could fix that.
We'll think about it. Any members of the public wish to testify that have not testified already?
Yes. Red's hot. Hot mic. Senator Abbas, Senator Long. My name is Robert Tangway, and I oppose this bill, and so does Mr. Z. My child's stuffed animal, I have not seen my children in over 2 years. A couple things that I want to point out is we're going to hear a narrative today from the state and the legislators out of Children and Family Law that, you know, this is in the best interest of the people and the fathers and, or not the fathers, just the people who need child support. Yes.
Just to clarify, are you testifying in opposition to House Bill 213?
Correct.
Thank you.
Okay. So it's an expedient to legislate, and it's on false terms. We really need to be removing 173B, which is unconstitutional, which is causing a lot of duress. The state gets funding from the federal government. Over 1/3 of our budget comes from federal grants. So there's over $9 billion that we get in federal and total revenues, and over $3.5 billion, or approximately $3.5 billion, comes from federal grants. These are numbers from New Hampshire Fiscal Policy Institute. Of that, a large majority of 1/3 goes to the Department of DHHS. So what we have is a system of servitude which offers a candy bucket or incentivizes families to break up at the cost of families and the general public. So the state gets lots of money, and further, lawyers get lots of money. And child support was originally created for oopsies and absent parents, which were at that point typically fathers. Picture of the 1930s, Dust Bowl America. Someone goes into a town and has a child, and then they never see anybody and they track them down. That's where it started. It wasn't until the 90s where we really started getting a lot of federal money.
If I just may, this bill is involving wage garnishments in simply a court form if the parties want to voluntarily enter into their own private arrangement, and it's just a form the court would create. It's not impacting child support guidelines, how much is paid, the system itself. It's not making any change on any of those issues other than what's in the bill.
I respectfully disagree. First of all, there's no such thing as wage garnishment in the statute. The statute is called income assignment, and that definition is not defined. You have to look into case law, which is income assignment, which is or the doctrine of income assignment, which is for income, and it basically says that income earned cannot be assigned to anybody else to avoid taxes. That's typically how it is. So you earn income tax, you can't give that to someone else so that you can get a lower tax burden, you know, with the bracket system. So it's not garnished. It's called income assignment. And what we have, but also part of 458, is that it's a lawful order. It must be a lawful order. And really what's happening is DHHS, the state, is contracting with the courts to rush litigants through and retaliate against pro se individuals to get federal grant money. And how they get the federal grant money is by creating child support orders. It does not matter how much the child support order is. All that matters is that there is a child support order. And that is, so when you see all this legislature, when you look at through that, those optics, you're going to see a scheme of getting federal grant money. That federal grant money may dry up. We are extensively in debt. And then it also creates incentives for families to break up. And what the state's not, as I believe as Rep. DeSimone said, she can't even get the number of people who are in arrearages. Can't even get the number of total people who are under child support, let alone arrearages. And then further, I've also requested what percentage of them are men and what percentage of them are women. So you're also seeing a systemic violation, which leaves the state open to lawsuit, because the state, again, is entering a contract with the federal government to get child support, and they're pushing it through at the behest of lawyers, family court lawyers who charge $250 to $350 to $400 an hour to cause contention. Now, if there was no contention and no child support of any logical amount, people were allowed to willingly pay, there would be less fighting. For instance, so how the state controls it and the courts control it, if I may.
No,
well,
if I just may,
Yes.
we are behind schedule and that we have a full room here. This has to do with wage garnishments that involve child support, not the ideology behind child support, the grant money,
Yes.
whether we agree with the child support laws, whether it's just, whether it's equal.
I'm getting to that right
I appreciate
now.
what you're saying, but if we
So,
can say
so the
bill,
state
it'd be
wants
appreciated.
an enforcement mechanism because they create incentive. Now, as I was saying, if they do not have a sizable amount, people are less likely to use the system. They're less likely to break up because they cannot financially handle two households. And secondly, they're not going to pay for a lawyer that's going to promise them a $250,000 judgment, which is what child support is. It says it in the law. A child support order is a judgment. So they have an enforcement mechanism, and you guys want this enforcement mechanism, but it has nowhere RSA 546A:5 where wealth shall be considered, and that's assets. So I oppose this bill as inexpedient to legislate, and you guys should be asking questions because I understand this completely and I have experience with it firsthand. And the basis for all of my problems is child support, and many of the problems. We're breaking up families to award a candy bucket to one party, which is typically a woman, which typically gets the children, which typically gets the child support money. And that must be substantial, otherwise they wouldn't do it. So that's how you get child support orders of $1,000 a month, $2,000, $3,000 a month for working class people, while they have to maintain a separate household, which is really causing the problem with housing in the state of New Hampshire. I'd be happy to answer any questions. Thank you.
Thank you for your testimony. Are there any members of the public who wish to testify on HB 213 who have not testified already? Seeing none, we will now close the public hearing on House Bill 213. At this time, we'll now open the public hearing on HB 243. This time, the chair recognizes Representative Spillane to introduce the bill.
Thank you, Mr. Chairman, members of the Senate. I'll try to be brief because this is not the first time you've seen this. This bill was passed through the House 3 times last term. It was passed in the first year. It became then the position of the House and was passed again in the second year. It was then put in a bill from the Senate to the House as an amendment to send back over, and again, did not make it back. In a prior year, prior to last term, it was also passed once. Every time I bring it forward, I get more and more people contacting me, explaining how important it is that we do something. And so I will briefly explain where the bill now stands. The language was come to as an agreement with myself and the former director at DCYF, Joe Ribson. He felt strongly that we should have something, as many other states do, including California, New York, Massachusetts, for false reports of child neglect and abuse. We did not get rid of the ability for anonymous reports to be made, but we encourage people to leave their name and contact information. Director Ribson was very adamant that that allows them to follow up, and so he likes the idea that we encourage it but he didn't want to completely remove the ability for anonymous if the needs arose. It includes language that may be delivered to a person who's making a report by one of the people who receive the reports at Children and Family Services, in the instance where they may recognize the voice and they know the person's a frequent reporter. They can give them language over the phone that basically lets them know that if it's made knowingly false with intent to harm, that they could be charged with something. In the intent to discourage false reports that are done maliciously as a form of swatting, to essentially get back at somebody. This doesn't change any of the way that we currently take the reports. It doesn't change any of the ability to take anonymous reports. It should not provide a chilling effect on somebody to make a real report, because the bar that you would have to reach to be able to prove that it is made knowingly false with intent to harm someone is a very high bar, and we did that on purpose. Because what we're really targeting here is the repeat offenders, the abusers of the system, the ones who are drawing time away from DCYF where they should be spending the time on real cases like the Harmony Montgomery case. I can give you an example of my real world situation. I'm sure you'll hear others. While I was serving as a state representative, there was one instance when I was at home with my family, and my middle child is diagnosed with a dual diagnosis of ADHD and ODD. And a person called and reported to the Department of Protective Services that my now ex-wife was burning him with cigarette butts and locking him in the basement. So I was not the direct target, but it was because of my politics that somebody made this accusation. And at midnight, police showed up at my front door, and I live out in the middle of nowhere. And it could have been very easy for me to answer the door carrying my firearm, because people don't come out to my door at midnight in the dark. But one of the officers, very with great forethought, was looking through the window with a light flashing on his badge so I could see that it was police. Upon answering the door, they demanded to talk to my wife and to see my son. So I had to wake up my middle son and get him downstairs, and he was required to strip naked to be searched for cigarette burns in the foyer in front of the two police officers he did not know. And upon seeing that there were no burns or anything, I informed them that whoever made the call didn't even know what my house was like, because the basement door doesn't lock. And I showed them the basement door. They considered that case unfounded at that point. And the reason I bring this case up in my own personal experience is because I have heard frequently that, well, if the case is unfounded, then it really didn't harm the family or the children. And I believe that those faults, the fact that we don't do anything as a state to discourage and prevent or penalize people who make these false reports, is almost like the state sanctioning a mental abuse situation, is because not only did it cause trauma to my family, my son refused to go to bed without wearing his street clothes for a month because he was afraid he'd be woken up in the middle of the night and made to strip naked in front of strangers again. It does cause trauma. It does cause strife, even if it's unfounded. It's a form of swatting. It is used maliciously, and it can be used against anyone at any time. It could be one of you next. It could be me again. It could be anyone sitting here behind me, because we don't have any penalty. So if I go and I pull a fire alarm, I can be charged with a crime for falsely pulling a fire alarm. And I bet you if I went out here and did it, I would be charged, even though I'm a sitting representative, because I falsely pulled a fire alarm. If I make a false police report, I can be charged with a crime. But I could have a beef with my neighbor and call repeatedly with false reports that I see them abusing their children over and over again. I could stand in my front yard and wave as DCYF comes and make it very clear that I'm the one doing it, and they're going to say, "It's nothing we can do." This situation shouldn't be allowed to continue when there is a known pattern, and that's why the bar is high, but there should be a penalty. And there's a part of this that also says it's open to civil, and I believe that's important because if somebody does have to seek counseling or recover attorney's fees, that should be allowed to be pursued by somebody in a civil action. And with that, I'll end my testimony because this isn't a new bill to you. I'm sure you've heard a lot, and there are a lot of people still to testify, I believe. So I'll take any questions if you have them.
Senator Long.
Thank you, Mr. Chairman. Thank you, Representative. Now, did you know who falsely reported?
We never found out. We never found out.
Okay.
But I think that if word got around, I believe that if this bill passes and a case or two cases are made and it becomes known that we're not going to let people use this as a form of swatting, that they can't just get away with it, someone will think twice before they do that.
Okay, thank you.
Representative, if I may inquire, and I'm just looking for it, if I understand what this says about criminal or civil liability, what exactly is the criminal charge? Is it a misdemeanor?
I believe it's a misdemeanor. I will also add, we brought it up, we did last year add a section in here to also be able to likewise charge a mandatory reporter, a professional mandatory reporter who fails to report. Because although we've always had that, there was never a penalty assigned to it. So this would actually put that misdemeanor penalty on a professional mandatory reporter. And we had to say professional mandatory reporter to narrow it to those people who work in the profession that would make them a mandatory reporter, because every single person in New Hampshire is by definition a mandatory reporter. And we wanted to make sure that it's just failure to report by those people like guidance counselors, doctors, counselors, attorneys, those people who should know because they've been professionally told, trained, and their license is at stake. The only enforcement mechanism prior to this was potentially a licensing revocation. And there was a request when it was in the House committee last term to allow a penalty to be put in place for somebody who failed to do their job in a professional capacity.
Thank you. Senator Long.
Thank you, Mr. Chairman. So as a counselor, I'm counseling these kids. Somebody comes up to me and says, hey, Johnny's father has been beating his mother and also at times beating a child. So we're all mandatory reporters, but I'm a professional. That's not the fact that person that's telling the counselor is looking to set up the family. So how would that come about? I couldn't be charged with a false report.
No.
Because I had somebody tell me.
And in fact, when we drafted this the first time, the reason it came up as a concern that failure to report should also be penalized was because there's broad exclusion from those professional mandatory reporters for filing a report and getting charged with making a knowingly false with intent to harm report. We wanted to make it clear that that's something you need to do, you're required to do. But at the same time, if you fail to do when you know there is a report you should have made, that you would be charged for failure to make a report.
Okay,
So to try to balance that out.
very good. Thank you.
Representative, thank you for your testimony.
Thank you.
At this time, the chair recognizes the Honorable Betty Gay.
Thank you for taking my testimony. As you can see, this whole area of law is of great concern to me, and I have invested several years in submitting bills and testifying on bills, and whatever way I could to get people interested. This is an ugly ugly part of our culture, and it's not fun to talk about. And a lot of people, we need these kind of bills because a lot of people shy away from when they see it, because it does put them on the spot to be held accountable for reporting it, or for not blocking people who are using it as a weapon. I know too many people who have had false reports filed against them out of just sheer nastiness. And because they never had to give their name, they could do it without fear of reprisal. So this bill actually is kind of like a foot in the door, because I would say on line 10, reports made to the department may include the name, address, and phone number. I would like that mandatory. But right now, we're still kind of overcoming objections from people who are so afraid that this will discourage people from reporting out of fear. But there's also the case, excuse me, I'm glad that they've also added in on line 23 about professional mandatory reporting, because like one nurse that I know, when I was speaking about this issue, she said, oh, some doctors, like ERs, they see it, but they don't want to report it because they don't want to go to court. And we all know that to go to court can usually mean a day of work missed. And so I think we need to come up with some more bills to make it more possible for professionals to file like online, like a Zoom type, because we really don't want to tie up ER physicians. It's hard enough to find them, and take one away for a whole day to go testify. I'm glad to see another bill that said people would be recompensed if the case was continued a second time, but the first time is enough. So to discourage people. So I think this bill is very, very necessary. I'm really glad that it covers both failure to report and false statements. And I'm sure there are lots of people sitting in here who will be able to tell you that they have experienced false allegations against them, because the people fear no reprisals. It's time that we did that. And yes, it is a challenging decision. You have to be very responsible to make a decision in either direction. But it's necessary. We have to grow up and do what we're responsible for. Again, I wish that on line 10 it didn't say the reports may include. I really think that it ought to. It'd be mandatory to acknowledge that you're filing either way. Thank you.
Seeing no questions, thank you for your testimony. At this time, the chair recognizes Emily Lawrence.
Good morning. Good morning. Good morning, Chairman Abbas and esteemed members of the Children and Family Law Committee. My name is Emily Lawrence, and I'm the Advocacy Director with Waypoint. Just to give you a little background on Waypoint, we are a nonprofit statewide agency that provides services to children and families, and that includes court-ordered services for children and families that are involved with the Division for Children, Youth, and Families, as well as community-based voluntary services for at-risk families, family reunification and parenting services, and also mental health counseling, among other things. I want to thank you for the opportunity to speak to you today about House Bill 243. I'm here on behalf of Waypoint, opposed to House Bill 243, and I just want to share a couple of points of concern for consideration, and we'll rely on the details in my written testimony. Our main concern is that the bill will have a chilling effect, and you've already heard that from some of the prior speakers, that they are saying that they're not concerned about that. We are concerned, and we certainly understand concerns for false reporting. I don't want to dismiss those concerns. In my prior role, I heard those concerns from constituents. but where we have, luckily in that role, that was few and far between. And I think what you have is a balancing act, and we would say that we would err on the side of caution and prefer that we encourage more reports than less to protect children. Again, I don't want to dismiss those concerns, but for us, the importance of the safety of the child is paramount. And even if there's one report that's missed, that could be harmful for a child. I am worried that the average person may be reluctant to report already. We've heard that in surveys that we've seen before, that people are concerned about reporting for fear of disrupting families, for not even knowing the process for reporting. And so they may not appreciate the language in the statute that it requires them to have malicious or with intent to harm for it to be a false report. And so for those reasons, those are really the primary reasons. I do think there are concerns kind of with the flip of what people are saying with the false reporting in domestic violence situations where the statute could be used as a weapon. Someone could say, if you're going to report this abuse, I'm going to report that it was done maliciously. And so victims may be reluctant to report legitimate abuse. So I think it is a balancing act that you're going to have to look at to see where you want to land. And we would land on the side for children. I will say that if you're looking at implementing this language, I think there are other ways to do so that could have an alternate statutory scheme. So for example, in Massachusetts, they have a graduated penalty scheme. So they start out with a fine for the first false report. For the second, then they would go to imprisonment. And then the third is both imprisonment and a fine. Other states simply remove immunity from civil or criminal prosecution. And that's similar to the language that is already in the bill on page 1, lines 22 to 25 for professional mandatory reporters who fail to make a report or knowingly file a false report. So that would be another alternative to the criminal penalty. Or you could take a more nuanced approach and leave it to the discretion of the judge so that the judge could determine based upon the circumstances of the case whether a fine or a misdemeanor was what would be needed for the penalty. And then I'll just note that I think that the language is a bit confusing on page 1, line 23, referring to professional mandatory reporter, and to some extent on page 2, lines 8 to 11, although that section does reference 169C29, but we know that anyone who suspects abuse or neglect is a mandatory reporter. And the statute 169C29, which is the mandatory reporting statute, enumerates those professions that have already been discussed by other speakers. And I just wonder if it might be clearer to reference that in both of these sections clearly, that those are the, in fact, professional capacities that are being referred to. And I put some suggested language in my written testimony. So thank you very much for hearing me, and I'd be happy to take any questions.
Thank you for your testimony. If I may inquire.
Sure.
I appreciate what you're saying, that you don't want to discourage people from reporting suspected abuse or neglect. But we have a criminal penalty already for someone who files a restraining order under false information. So I guess what would the concern be of having a similar policy for involving DCYF complaints?
Again, I think we just believe that it could have a chilling effect, and we would hate for one person to not report abuse of a child. I mean, a child is, I would argue, different than an adult coming in to file a restraining order against mostly another adult, right? And here we're talking about potential concerns for children. So, and I acknowledge it's a balancing act. And so I guess we would just continue to argue that those concerns are paramount.
If I can just follow up. But
Sure.
I'm assuming the mandated reporter is an adult. I understand that maybe that's not technically the case, but I guess in a restraining order, it's still the same. I'm looking at an adult is filing that petition because they're on the receiving end of abuse, and they want a protective order. If they file a
Correct.
false one, it's a criminal penalty. If an adult is filing one, reporting abuse or neglect to the department, I understand it's on behalf of a child, but it's still the adult making the report.
It is the adult making the report, but it's about a concern for a child who doesn't have that opportunity. I think I mean, arguably, yes, someone could file a restraining order on behalf of a child. I know that there's been laws that you guys have been looking at that. But my point being that this is someone who is reporting concerns about a child who is a more vulnerable, probably the most vulnerable individual in our environment, right? Like, they don't have that ability to make any report. And we want to make sure that we know when there are concerns about that, and people may be, I mean, I have heard people are leery of reporting if they think that there is a concern. I will say we did look for studies in other states that have these, because there are a number of other states that have these laws. I did not find any saying that reporting had decreased, but I'm guessing that's not because they know, but because it simply hasn't been studied. I didn't find anything either way.
Thank you. Senator Sullivan.
Thank you, Mr. Chairman. Thank you for taking my question. You stated that children are different. I agree. But isn't the core of this is to prevent children whose families are innocent from undergoing trauma that can take years to actually undo? I mean, what happened to Representative Spillane's family? I would actually like to have a review of the process of how we're handling cases like this, because that seems completely, I think I would not have behaved well if that was happening to my child. But don't you think at the crux of this, it is really to protect the children and the families that are innocent from people that are just, we see swatting happening more and more. And this is the one area where there are no repercussions for that.
Sure. I think, and I agree that what happened to Representative Spillane's family was very unfortunate, or beyond that, right? That was trauma. As I said in my prior role, I reviewed a number of cases, and I did not see that happening really. I can't think of one. I would hope that from my experience, that is rare. It's an unfortunate rarity for sure. We also have processes through DCYF in how they screen these. So, for example, when you bring a restraining order, you have to go to court and you have to prove that. Here, you have to call DCYF, and they have a process to go through that before they would even presumably screen it into the level that it reached in Representative Spillane's case. So, again, that's unfortunate. It was mentioned by another prior person who testified, like, well, what if someone continues to report and continues to report? And my understanding from working with DCYF is that when that happens, they're pretty aware that this is a repeat caller, and so those are the ones that are screened out. To your point about trauma to children, it is true that even having an assessment called in, so when it's called in, it can either be screened out or screened in. If it's screened in, it will go to the assessment level, which is presumably what happened in Representative Spillane's case. In that case, it can be traumatizing even just to have that happen, for sure. I think we would still, our role here is to say that we want to make sure that all children are protected, and we already know that sometimes people don't report. Again, if you're going to go down the road of having something, we would then argue for this graduated approach, or for just a slightly different approach that was maybe less daunting to people, and so that we could still, that could be a balance for both sides.
Senator Long.
Thank you, Mr. Chairman. So, restraining orders, the difference between this and restraining orders is we know who the person that's requesting a restraining order. We don't know now. So any states, do you know of any states that require you give a name when you report?
That's a good question, and I don't know the answer to that.
okay.
I'm happy to find that out, and maybe there is someone from DCYF here, and Attorney Larrabee may know that. But
Okay, I could ask him to follow if I may. And you also stated that DCYF at times knows that this is somebody repeatedly false.
Yes.
Do you know if they take action on that, or they just?
As far as I know, they don't. I don't believe they have any authority to take action on that, unless it could be. And I have I can recall cases where someone would report someone who was repeatedly calling in, because that could become an abusive situation. If one parent is continuing to call in on another parent, and there's no substantiation for that. But I don't think that they take any action beyond maybe screening it out. Again, I would defer to DCYF on that.
Okay, thank you.
Sure.
Thank you for your testimony.
Thank you.
At this time, the chair recognizes Representative DeSimone.
Thank you again, Mr. Chairman and esteemed committee members. Again, my name is Deborah DeSimone. I represent Rockingham 18 Atkinson. For Senator Long, the question you asked is if any other state requires the name. 16 states do. There is also a requirement in 47 other states for mandatory reporters, and in many of those states, there are penalties for not reporting. However, there are 29 states that currently have laws that require penalties for false reporting. So what I really want to get to here is I want to get to the other side of this false reporting. With all due respect to Waypoint and the amazing work that they do, and without Waypoint, this state would be in deep trouble with the families that Waypoint is able to help the way they do. They're a great nonprofit organization. But what I want to bring forward is, for every false report that's called in, that's an actual report that has to be put on the back burner. Because every report that comes in for child abuse has to be looked at and decided whether it's going to be forgotten or whether it is actually a case that needs to be looked into. And that takes time. It takes a lot of time out of the employee's day to figure out which is and which is not a false report. Now, if you exacerbate that amount of time by the many, many, many calls that a particular vindictive person would make, that's how many children who are being abused are not getting the help that they need. That's my concern about false reporting. We live in a state where we don't brush things off here. We investigate every allegation. And that's phenomenal. That's what makes this state a great state. But because of that, there are kids. There have just been 3 reported this week. A baby found in a lake. Nobody reported any abuse, not even falsely. A little boy who was murdered because the boyfriend did something and nobody reported the abuse. This law is not going to change that. There are people who are not going to report the abuse when they see it. This law is not in effect. It has nothing to do with the fact that false reporters will be penalized, that these people are already not reporting. I think we need to strengthen this law, and we may be able to save more children by spending more time investigating actual reports and letting the people who are viciously attacking people, giving false reports, can be put on notice. This state's not going to allow it. Thank you for allowing me to speak.
Thank you, Representative. This time, the chair recognizes Cassandra Sanchez.
Good morning. For the record, Cassandra Sanchez, Child Advocate for the state of New Hampshire.
Attorney Lissa Massio, Associate Child Advocate.
Thank you for allowing us to speak today. We are here in opposition of House Bill 243. As you heard prior today from Emily Lawrence, the representative for Waypoint, we too believe that this could result in a chilling effect on reporting. And in our role of protecting best interests of children and safety being paramount to the best interests of children, we do feel strongly that reporting needs to be easily accessible, and we need to allow the professionals within the division to make the determination as to whether a report is something that they are going to further assess or not. And so just to set the stage a bit, to make sure it is very clear how that process works, if somebody is concerned about abuse and neglect of a child, they call into central intake in DCYF. That central intake worker collects information. At the time of collecting information, they are going to determine whether they're going to screen in that call for an assessment to further look into the case to contact the family, or they screen it out, at which time they do not contact the family whatsoever. The data I have for last year's reporting, just over 50% of calls into central intake were screened out. So they are doing a fairly good job assessing and screening out when it is and when it is not necessary to become involved with the family. With that, they are also then reducing trauma to those families because they are then not contacting them. They get the call, they're making that decision internally, and then therefore that does not result in trauma to those particular families. With that, it is important to note as well that throughout this process, we are already asking those screeners to look at the information that is before them, to look at the laws in which the agency operates and determine whether it is a screened in or screened out call. This bill would then add another task on top of that, of them having to determine whether it is a false allegation. If we're talking about the amount of work that those social workers are already managing, adding another task like this onto their plate, which they are not trained to do, is going to take away from the time that they are answering those phone calls and making those determinations based off of the law. So we do want to be mindful of that, as well as that there is nothing in here indicating how they are going to learn and be able to assess and make that determination to then move forward with whether they are the ones to file or they are reporting that there has been false allegations called in. It's also important to differentiate repeated callers from false reporting. Just because somebody repeatedly calls the agency does not mean that it is false reporting. Unfortunately, we have witnessed some very tragic outcomes when there have been repeated callers. If we want to use the case of Harmony Montgomery as an example, that is a perfect example. Mom was a repeated caller. Mom's calls were screened out. That child was in danger. That child, unfortunately, is no longer with us today. And so it is important to recognize that if somebody had taken that as mom being a false reporter and she was then charged, we are not taking that concern seriously. Nobody would have been intervening to look out for that child. And so it is important to make sure there is a very clear differentiation that there may be people that are tagged as frequent flyers, but it is important that every time somebody calls, regardless of the person's name, who they are that's calling, that the concerns that they are sharing being taken seriously by the division, and again, considered against the way in which our abuse and neglect laws are written to determine if it is worth a screen in or screen out determination. In regard to that, in addition to that, we do worry about those who may be calling in, then going even further with the child if they are afraid that they could be, that there could be charges against them for either false reporting or for not reporting, that some of those mandated reporters may go back to the child and ask additional questions to feel that they have enough information to call it in and ensure that they are following the law. And in doing that, that can impede criminal investigations, and that can actually interfere with a child's disclosure of information. If a child is repeatedly being asked to tell their story, they start to change their story with adults because they feel that I'm not given the right answer the first time, so now I'm going to say something else. So an initial outcry of abuse or neglect, if asked repeatedly, could change to nothing happened, and then what? An outcry that is very serious is now not being investigated by law enforcement or by child protection because because of the pre-questioning and the child's story then being watered down and shifting over time. And so we want to make sure that we are giving it to the professionals to make that assessment and that folks are not going back to the children and attempting to gather more information. It is also important to know that the no and tell training that we have in this state says that if anybody knows of or even suspects abuse or neglect of a child, they are to call. And so that is the messaging that is going out across the state right now. Even if you suspect it, call anyways. We do not want anything in law that's going to conflict with that messaging. Because we have the mandated reporting laws we have here in New Hampshire, which are extremely broad and they are not specific to professionals, we need all adults to know that if they see something, they need to say something. And I do fear that this law will conflict with that. I am open to any questions.
Add any testimony?
I'm here for moral legal support.
Thank you for taking my question. Thank you. So hearing that Harvey Montgomery's mother called repeatedly and that she still was murdered is really troubling to hear. I think for a lot of people that the system completely failed her. But when it comes to you said 50% of the calls result in being screened out. So wouldn't this bill actually help alleviate that pressure on the system of those 50%? And that's half of the calls coming in are not being screened because they're not being deemed relevant. So wouldn't this bill actually help with that case and free up time for the caseworkers?
I don't believe so because not in that particular year, but in the year that Harmony's case was being called in, they would have been part of that percentage of screened out calls. And that was something that was really happening. So it is important for that information to get to the screeners. Oftentimes, it may take multiple calls to put the picture together. So it may be a school provider calling and saying the child is coming to school dirty. And then it may be an in-home provider saying, the parent isn't getting out of bed to care for the child, and that first call from the teacher about the child coming to school dirty gets screened out, but an in-home provider saying, mom can't get out of bed and care for this child, now adds on to that initial call that had come in, and now it builds out the story of what this child is experiencing and what they're living in. And so those prior calls do have an importance to them, and they do oftentimes build into a story because each person working with a child does not see a whole picture of their life. They typically get a real small snapshot, specifically if we're talking about school professionals or pediatricians who maybe see a child once or twice a year. That pediatrician's concern may not be enough to screen in, but if you have a pediatrician plus school plus somebody else, now it's rising to the level of, oh, we're seeing the full picture of what this child is living in.
And I think it's also important to be careful to not conflate screened out or even unfounded with being false. There's a large difference, and the point is it's the professionals at DCYF who should be making the decision, not a layperson, and frankly, not even a professional reporter. That's why we have the no and tell. That's why we have the professionals working intake and doing the assessments, and that's the chilling effect that we're afraid of.
Thank you. So I just want to make it really clear that, so if there was a comment made that, suspected abuse might not be called in, the bill is really clear about it being malicious or with intent to harm. So that's not, if you suspect someone of hurting a child and you call it in, that is not with malicious intent. Would you agree with that?
I agree that it's not with malicious intent, but I do not agree that people will not interpret this that if they are calling and do not have enough information, that they could be accused of malicious intent. And that is where the chilling effect comes in.
I think also it's, to answer a prior question of someone else, by giving that warning, a lay person who does not have malicious intent may have that chilling effect and be frightened. However, someone who truly is calling with malicious intent just won't give their name. So the implications of whether the efficacy of this is also in question of the truly malicious intent, they're just not going to give their name, so then there's no enforcement anyway. Whereas the folks who didn't have malicious intent, but that warning is going to then frighten them, may not make the report, or they may not then give their name, whereas before they would have. And having that name is really helpful for DCYF, the professionals, to do their jobs and do adequate follow-up. So the other perhaps unintended consequence of this warning would be that more people wouldn't give their name, which actually would make it harder for DCYF to protect children.
If I may inquire with a question, and I don't suspect this may change your position on this, but as we talked about culpability, it uses the term maliciously, which if you go to RSA 626:2, that's like, maliciously is actually not one of the mental states for culpability. But I looked at some other laws that have involved false reporting. Oddly enough, the restraining order law does not state what the mental state should be. Address that later. But for making a false police report, it's RSA 641:4, uses the term knowingly as the mental state. So maliciously was changed to knowingly. I guess I appreciate the chilling effect, but in that case, knowingly, a person acts knowingly with respect to conduct or to a circumstance that is a material element to an offense. So I think in that case, it's clear that it's not what they suspect. They know what they're reporting is false, and they're doing it anyway. In that case, if we changed it or amended it to actually knowingly, would that hopefully maybe reduce this unintended consequence that you speak of?
I think there's a lot of different words that could be used, and as you're saying, there's different words used throughout. I think the two issues there is lay people aren't going to know the difference. I mean, as lawyers, we can talk about all those different mental states. A lay person, especially someone who's probably already under a bit of stress because they've picked up the phone to call central intake, which most people don't like to do, it's intimidating, won't know. But also, I think on the back end of that, what Cassandra mentioned earlier is who's investigating that? Who's going to be proving? Now you're trying to go find this caller to prove what they knew. Like that, I don't even know who would be investigating that, but if it's the DCYF assessment workers, they're already busy trying to protect children. So there's also just sort of the logistics of who's proving if it's malicious, if it's knowing, if it's intentional. That's, again, used in these other law enforcement contexts where a law enforcement investigator is trained to do that, to investigate mens rea, and prosecutors who are also, as a former DCYF prosecutor, we don't investigate intent there as much within 169C definition. So it leaves open that question of who's doing that, how much time does that take, how much time does that take away from actually doing the child protection piece?
And if I could follow up, I don't interpret this that DCYF would have to investigate that side of this. The prosecution, that's left for the AG's office or the county attorney's office. But what I'm thinking is the application of this, if it became law, would really, if it's screened out, the person who it was filed against is not even going to know about it, I can imagine. So I think this would really apply when a complaint is screened in, and then there's an investigation that's followed up. And if it turns out to be, if it uncovers information, that's when I think this would apply in the real world, how it would be investigated. I don't see, do you see a circumstance where screened out reports would actually even give, I don't think it's nothing's arising from it. So.
I mean, I think that'd be a good question. I know Susan Larrabee, the attorney for DCYF's here. Their screened out calls are also retained, as we said earlier, to build that sort of record. If you have 5 calls on the same person, there are ability for people whose complaints are made against to get some of those records. I think there are also circumstances, we've heard stories where in a contentious divorce or parenting case, the people are saying back and forth, I've called you in, I'm going to call you in. It's used as threats and intimidation. So you're probably correct that it would more often be when an actual investigation occurs, but I don't think you could necessarily rule out. And with all the civil penalties, I can certainly imagine situations where folks are in a contentious situation and filing civil penalties for, believed reports, or say 5 get screened out, but 1 gets screened in. Is each one an offense? Because you now know it got screened in at some point. So it would be difficult to really suss out the consequences.
And just in addition to that, I think your question for me brings about more questions, actually. How would that play out? How would that impact DCYF? So if they're not involved in the one being investigating it, are they going to be called into court to testify about their interactions with the family, about conversations that were had, right? I don't know. I don't know how that would play out. I'm not sure that this bill clarifies that. And so it leads me to have more questions about what other unintended consequences and ways could this impact the day-to-day work of social workers.
And one last follow-up. I certainly appreciate not wanting to waste resources investigating things that have no merit to it. But what about the complaints screened in that if it turns out it's without question it was done knowingly or intentionally, someone filed a false report? And now there's a lot of department resources that go into that and what's the consequence for the person who intentionally filed the false report? I mean, I'm looking at it both ways. I mean, that's a tremendous administrative cost for all the members of the department doing what they're assigned to do, doing it in good faith, and it turns out someone is really abusing or misusing the system intentionally. So, I mean, what about that side of the administrative cost savings?
I could just say from our perspective in our oversight role, we're not seeing that play out in cases. The cases that are coming before us, we do receive calls to our office from parents, like Lisa had mentioned, some of them being contentious divorce cases, and we can go right into the DCYF case records and read the work that they're doing. And we are not finding that they are intervening in families that intervention is not necessary. Is the burden high for them to have a finding? Absolutely. So is their finding rate very low? It is, particularly compared to other states. But are they looking into situations that do require that level of assessment? That is what we are finding in our work, yes.
Thank you. Senator Long?
Thank you, Mr. Chairman. Do you know if we keep data on who is professionally putting in claims and who's rank and file? Do we have data on that?
There is some data that DCYF maintains about the, including the amount of calls from different professional reporters. Okay. The last public report that I had pulled, that data was up to date as of October 2024. There's been nothing more current than that. But it is broken down by different professions, and it shows the rate and the amount of calls that they've made each month over up to October 24 in prior years.
Okay.
Pretty broad categories.
Yes.
And just for what it's worth, I mean, listening to Representative Blaine's story, listening to other stories, when does CAC get involved? The Child Advocate Center.
The Child Advocacy Center.
I'm disturbed that kids are being interviewed by police, by unprofessionals. That was supposed to cease.
Yes. So CAC, typically the police as well as the DCYF caseworkers would be doing minimal facts interviews, which means they are gathering just the minimal amount of facts to determine if this rises to the level to be referred to a CAC. And then at that time, the referral can either come from law enforcement or it can come from DCYF directly to the CAC. And then they are to sit down with the child and have that further investigation. But to your point, that was where I was pointing out concern for people who may fear this statute going back to the child and asking more questions before a child is able to get to the CAC, which brings us back to the times before that existed, and we don't want to see that happening. We want to ensure that they can get to the appropriate entity that does forensic interviews, that will hold up in court, and that those are the ones who are diving deeper and asking those further questions of children.
Okay, thank you.
Yes.
Seeing no questions, thank you for your testimony.
Thank you.
At this time, the chair recognizes Stacy Terosian.
Good morning. Good morning, Senator Abbas, is that how you say it? And Senator Sullivan and Senator Long. Thank you for hearing my testimony today. I'm in support of House Bill 243. I had your assistant pass out some packets, and enclosed in those packets that I handed out to you is my testimony on the back page, the last, and then I also included a few of exhibits to show you. There's just a few, I have so many exhibits, of the attacks, the vicious attacks, malicious attacks and harassment that I've been exposed to, and showing you, supporting my testimony that these are the facts. I have personal experience into why this bill needs to be passed. I myself have been a victim, intentionally falsely accused of child abuse with malicious intent in a smear campaign against me by my own daughter. 3 years ago, in May of 2022, DCYF gave me custody of my 2 young granddaughters who were 4 and 5 years old because my daughter suffered a second overdose of heroin laced with fentanyl while her children were in the home. During that time, I had custody of my granddaughters. I was receiving Social Security disability benefits for my 5-year-old granddaughter. When the benefits stopped being direct deposited into my daughter's account, she got very upset with me that I was receiving these benefits and she was no longer collecting them. She stated that she needed the money more than I did and threatened me numerous times that if I did not give her this money that I was receiving, that when she got her girls back, I would never see them again. She kept stating that she needed these benefits more than I did, even though I was raising her children by myself. 8 months later, I supported the reunification of my daughter with her children. Upon this reunification, she restricted all contact between myself and my granddaughters. I tried reaching out to her numerous times through text to schedule visits with the girls and to pick them up and take them out. My daughter would pretend that I had the wrong cell phone number and respond inappropriately, saying things like, "Oh, you want to see the girls? There's special sites like Pornhub for that." Saying she had no mother and I must have the wrong number. After reunification, my granddaughters would secretly video call me from their iPads when their mom was sleeping, telling me they missed me, Mimi, and asked me to pick them up, that they were bored, Mama's sleeping, and they were hiding in their bedrooms to call me. So Mama wouldn't hear them, and that if she found out, she would be mad that they were talking to me, and she would take their iPads away from them if she found out. They were constantly calling myself and my sister Darlene, who was their auntie who they love, to come pick them up, but there was nothing that we could do. So I finally went down and I filed a petition for grandparent visitations. Immediately after my daughter received the petition, she went down to the Northampton PD, intentionally and maliciously filed a false report of child abuse on me and my boyfriend, Frank. She stated that I was duct taping my grandchildren's mouths and locking them in rooms when I had custody of them, forgetting why DCYF gave me custody, to keep them safe from her. She also filed one with DCYF. And she even told DCYF that she had video recordings of the girls stating the abuse I inflicted on them. The caseworker for DCYF interviewed the girls, and she said to me, "At no time, Stacy, did I ever see anything in that video stating what she is saying that you did. My daughter did this to hurt me and to block me in court from having any chance of getting any visitations with my granddaughters, who I love so much. But thankfully, Judge Cooper saw right through her lies and stated that she was not credible. She kept trying to use abuse charges on me in court to block me from seeing my grandchildren. The Northampton PD and DCYF both did a thorough investigation, and I did give you the report. It was emailed. And on the last page, there's some information. But into these accusations, and they found that these accusations were unfounded and the case was closed. We emailed you the Northampton PD report, and on the last page, the DCYF caseworker told the detective that my daughter wanted me to have consequences. and she was upset that I received Social Security benefits and I was able to claim the girls on my tax returns. My daughter felt that that money belonged to her and that I stole it, even though she didn't even have her children for those 8 months. She was also very upset with me because I left her dad, her best friend, due to his addictions. And she felt that I was the one who destroyed our family because I left him. He sadly passed away last year. So she has a lot of anger towards me and just wants to hurt me and punish me any way she can by fabricating malicious lies and posting it all over social media, slandering my good name. During our litigation, my daughter kept lying to the court, saying there was a current open case of child abuse against me, and there was new evidence in the case. And then when I would call the police department investigator, he would tell me the case is still closed, there's no new evidence. But she just kept calling them, constantly trying to reopen the case with no credible evidence. Furthermore, the DCYF caseworker testified at my hearing for my grandparent visitations and stated at no time she ever felt the girls were in danger or not safe with me, and that the girls were happy and thriving in my care and should continue to have a relationship with me and their extended family. We were also assigned a guardian ad litem by the court. Allison Lawrence through CASA was assigned to our case, and on her many visits with the girls and I, she was always impressed and praising me on how well the girls were adjusting and being cared for, and how well their speech was improving while with me, and that she was very happy with their progress, and the girls were always happy and thriving in my care. Well, after I filed my petition for grandparent visitation, my daughter also started viciously slandering me on social media via TikTok videos and Facebook, accusing me of child abuse and using lots of profanity and calling me vulgar names. She was also threatening me with voicemails that I was going to burn and I'm going down, which are all in those exhibits. She even went to the lengths of verbally and physically intimidating me and threatening me in the courthouse, to the point where the clerks had to call the security on her, and I had to get an order of protection against my own daughter so I could feel safe in court. My boyfriend and I were constantly being attacked by her and her agenda of falsifying police reports, falsifying sworn testimony in court, and falsifying statements to DCYF, and it was just a smear campaign against me. My daughter got away with intentionally falsifying a report with malicious intent, defamation of character, and libel, without any consequences whatsoever, which is why I'm here today in support of House Bill 243. My daughter, still today, just a couple of weeks ago, still is putting up TikTok videos, basically lip-syncing Eminem with swears and vulgar and with the mom word in there, defaming me all over social media and ruining my good name. I urge this committee to pass this bill today unencumbered. I also want to say that I just realized when DCYF investigated me, that stays on their report for 10 years. Even though they closed and unfounded it was unfounded, that stays on there for 10 years. And I was innocent of all of these charges that my daughter accused me of. And she's just so angry. She's doing everything to block me from seeing my grandchildren. And something needs to be done, or else people will keep continuing to do these things, to hurt, like myself, the grandmother, who loved and took care of these girls since they were born. And now I don't get to ever see them again. So I ask that you all please pass this bill, and if you have time to please take a look at the exhibits. I was the victim here of all these malicious attacks, and my boyfriend as well. She's defaming him about being a veteran, smearing his name all over social media, and it doesn't stop. Even on Facebook, awful Mother's Day posts, vulgar language that you would never think a child would come out of a child's mouth to their mother. And also, I may have enclosed it in another packet, when my daughter was incarcerated, she did write a very nice letter to me because now she was clean. She wasn't on anything, and she realized, let me tell my mother how I really feel. And it might not be in that packet, but it might be in the grandparent one that I'm supporting as well for grandparents. But thank you so much for your time, and I really hope this bill gets passed. You're welcome. Did anybody have any questions? No? Okay.
Thank you for your testimony.
You're welcome.
This time the chair recognizes Susan Larrabee.
Good morning, Chairman Abbas, members of the committee. My name is Susan Larrabee. I am General Counsel and Legislative Liaison for DCYF, Department of Health and Human Services. Although we take no position on this bill, I'm happy to answer any questions and possibly can start with providing some context and information regarding our DCYF practices, since they've been referenced numerous times today. Before I do that, I would like to thank you all, as well as the representatives who testified today. Without a doubt, I know everyone in this room is concerned most about the best interest of our children in our state, and I applaud that. And I do recognize that there has been a lot of work on this bill. And again, I just want to reiterate, and I think everyone in this room is very aware, but not everyone in New Hampshire is aware, because of the way our statute is written, that every adult in New Hampshire is a mandatory reporter. We're far and above many states, and we've had that on the books since 1979. Again, making us one of the first states to do that. And I think what gets confusing is that there's first a laundry list, and I don't mean to belittle professions by saying laundry list, but there is a very long list of professions that are stated first in that statute, because those professions have what's commonly referred to as a privileged communication between, whether it be their clients, their patients, their students, that would provide confidentiality in normal circumstances when it comes to things that are being told. But because this bill supersedes that, in which, again, every adult in New Hampshire is a mandatory reporter. Also, that goes above and beyond any immunity that a priest, a doctor may have with their client if a client is telling them something that leads them to believe that a child has been abused and neglected. Furthermore, this has been addressed slightly, and I'm not sure if it's been fully understood. 169C39 already provides for a criminal penalty for those who fail to report. And again, for everyone who fails to report. And I can say, as a former prosecutor for over 20-something years, specializing in crimes against children, I have used that statute. It's very clear and it's very concise. Anyone who knowingly violates any provision of this subdivision shall be guilty of a misdemeanor. And that too has been on the books since August 22nd of 1979. It is a mens rea, a mental state, knowingly. It is an actus reus of violating a provision of this section of 169C, and it gives you the penalty, which again, due process requires that everyone needs to know what they're being accused of and what the penalty is. And there, I don't want to get too off track, but that also is difficult to put criminal sanctions in a non-criminal section of the RSAs. When I was a prosecutor, you know, the 630s and the 600s is what I would look to. So it's very rare that I would look to other sections of the RSA because they're not criminal sections. And Chairman Abbas, as you recognized, the beginning of I think it's 626, RSA 626:2 talks about the culpable mental states in our state. Knowingly, purposely, recklessly, criminal neglect, the different mens reas, just a Latin term for mental state. And then it goes through all the criminal acts after that. And that's where you look to for criminal sanctions. And I know we've pointed out a little bit today, and I will address that there are criminal sanctions for false reporting in different venues. 630 641:4, which has been referenced numerous times today, provides for criminal sanctions when there's a false report to law enforcement. And I will ask this committee, I think it's important to look at how that is worded if you're looking for maybe a solution to, again, a happy medium with what everyone is trying to address here. That we do not want, of course, we do not want a chilling effect on reporting. We've worked hand in hand with the Granite State Children's Alliance when it comes to what's called the Know and Tell campaign, the see something, say something, because it's hard for every adult in New Hampshire to know that they are mandatory reporters. It's hard to get that word out, and they've gone to schools, they've gone to Boys and Girls Clubs, they've gone to other avenues and venues to get that across, that when you see something that leads you to believe that a child has been abused or neglected, call it in, call this hotline. It's a 24-hour hotline, central intake, and I'll address that in a minute. So of course we want to keep going on that. What's part of that campaign is also letting people know that they have a duty to report. There's a criminal sanction for those who do not report. And there also is civil immunity and criminal immunity for those who report in what's called good faith. And that's written right into the reporting statute. That those who are based on a good faith have called it in will not be held criminally or civilly liable. But of course, we understand the need to want to balance to the weaponizing of false reports to DCYF. And I also want to address too, I mentioned false reports to law enforcement as one statute to look at. I would also ask that this committee looks at 641(3), unsworn falsification, in which a person is guilty of a misdemeanor if, with a purpose, I'm reading subsection B of that, with a purpose to deceive a public servant in the performance of his or her official function, he or she makes any written or electronic false statement which he or she does not believe to be true. I mean, I'm wondering again, it's up to this committee, and obviously I did not draft this bill, if there's something that could be done with that section of the statute, because DCYF, we are all public servants as part of our professions in investigating abuse and neglect. And what was pointed out earlier, and I definitely want to address that, is that we are not criminal prosecutors. We don't have a function of filing charges against somebody. What happens is, when a case comes in, is called into central intake, as has already been discussed a little bit, and I want to add a little bit more context to it. The central intake worker, who is a child protection worker, is talking with the caller and is already getting as much information as possible from that caller. Who are they? Why do they think this has happened? How can if this gets screened in, how can we follow up with you for a very comprehensive interview? What is your name? What is your phone number? What is your address? What do you know? How do you know it? What are the details? And they go through a very comprehensive question and answering session with the person on the phone. They go through what's called a SDM, structured decision making. They look at the statute, they look at different guiding questions that they are asking the caller, and they're finding out as much information as possible. As I believe the Office of the Child Advocate referenced, there were over 27,000 reports to central intake last year. Of those 27,000 reports, only 1,203 were anonymous reports. Sometimes a caller starts off the conversation by not wanting to identify themselves. And the caller then feels comfortable enough through the give and take, through the question and answering with the social worker to give that information, because they are told how important it is that we want to follow up with you. We want to do our job fully. And talking with you on the phone is not the time or place. However, it is enough to possibly screen in that call. Does it meet the definition of abuse and neglect? If so, that's just the first step. that if that case is screened in, it is then referred to the district office that the event occurred in for a full assessment and investigation. At that time, if what they are screening in also could be a potential crime against a child in any way, that call and that information about that call is then sent to the local police department. And that begins at that point a joint investigation. At that point, the assessment worker is looking towards a 169C investigation, right? The civil abuse and neglect investigation. The law enforcement is doing a joint investigation, but they're parallel, they're not the same. They're looking at possible criminal charges. And Senator Long, yes, what you referenced is correct. At that point, that is when they also connect with the Child Advocacy Center and say, we would like to bring this child in for a full forensic interview in a child-focused, victim-centered way, in which law enforcement and DCYF are in a different room listening from a closed-circuit TV earpiece so they can hear and see that child, but that child only has to talk to one person, a trained forensic interview. So they're looking at two different things. And again, Representative Spillane, what happened to you was against all protocols, and I would ask you to report that, because we also have what's called the Attorney General's protocols on the investigation of abuse and neglect that's put out by the Attorney General's office, which explains to all of us involved in the investigation of abuse and neglect cases, including professional reporters, especially schools and the medical community, which are two of our three largest professional reporters. Police, schools, and medical are the three top callers of abuse and neglect, and explains to them their duties of how they are to be victim-centered, child-focused, in which a police officer should never be asking for a child to disrobe in any imaginable scenario in front of in their living room. So what happened to you was not appropriate by any means. Going back to the anonymous reporters, so of those 1,203 anonymous reports, of those 514 were then screened in for an investigation. So more than half of them were at that point screened out. Those that were screened in, again, that's just the first step in the investigation. I apologize. I'm trying to recollect if there were other things that were pointed and asked of DCYF that were maybe referenced in other people's testimony that I'm trying to draw from now. I would, again, just note that the way that the bill is written, there is some confusion that if I was still a prosecutor, I would be confused by. They don't give a penalty, there's no penalty addressed. It's not clear and concise, in which there is a mental state, an act that is done, a false report, and then the sanction. So I would ask that this committee look towards the criminal sanctions of false reporting to public servants and law enforcement as maybe a guide of what could possibly be used for if the false reporting is something that is feeling need to go forward. And I would, again, just address that failing to report, the duty to report is incumbent upon all of us as citizens of New Hampshire. And there is already a sanction under 169C39 for anyone who fails to report. Thank you. I'm happy to answer any questions.
And thank you for your testimony. And I agree that I think adding, not that anyone supports this or not, but it should say at least knowingly, so we have a good, clear, concise what the mental state is. Now, the scope of this, I'm on page 1, lines 28 to 30. I think in the example the representative gave, it appeared that that person contacted the department directly. But this would apply to statements to any court, any law enforcement agency, any social service agency, or any other mandated reporter. So for the application of this, is it the person, I think the testimony has really been focusing on someone contacting the department, making a false report, and that concern. But if you were to let's say, to get around that, I can tell one of the senators to my left or right, they're a mandated reporter, now they're making the report. I read this that it would apply to the statements I make to the person to my left or to my right as well. I think the law enforcement side of it, there's already an RSM point with that, but I guess application-wise, that's how I look at this, and as it would apply. And do you have any comment on whether it should be the person filing the report? But I also see, if it is limited to that, I see a clear loophole that you can get around that would frustrate the purpose here.
Right, and yes, and I would say already, again, in terms of a false report to any court, well, we already know that's a crime, that's perjury, that's sworn falsification. A false report to any law enforcement agency, we, again, have addressed that, that's already false reporting, 641:4. To any social service agency, that's what basically is the crux of this decision that you're making today, whether or not to criminalize the act of making a false report. And again, what is a false report in terms of, is it an oral, the oral conversation that's occurring with central intake, or is it going further when they are actually being interviewed, and how, in terms of the maliciously or with intent to harm? That's not standards that I'm familiar with as a former criminal prosecutor. It sounds like a civil liability with the word maliciously is very subjective. And you're saying that last part, to any professional report, mandatory reporter. And again, I would also say to carve out professional mandatory reporters, I don't understand, because again, every adult in New Hampshire is a mandatory reporter. So to carve out professional would also add to us having that constant issue of members of our community not understanding that everyone in New Hampshire is a mandatory reporter. So I guess, Senator Abbott, I'm sorry for not being direct in answering your question. I'm just kind of thinking out loud. But you're saying that last part, right? The person who then reports to somebody else, that they didn't report it to DCYF, but they reported it to somebody else because they thought that they believe that person will then call it in.
Well, so I was thinking out loud too when I asked the question. That's
Okay.
That's the problem. So I'll clarify. What I'm getting at is, I think it's clear that no one wants anyone filing a false report with the department. Now, that's easy because well, not easy, but you're dealing with the person you're dealing with is the one making the report. But this, as I read it, would apply if you make the false statement to a professional mandated report, and now that person's going to be the one making the report to the department. That's how I'm reading it. Some people are shaking their head. I'm asking you how you read it.
Again, criminally, how would you prosecute? So I would have to prove as a criminal prosecutor that you knew that telling that person would lead to a report to DCYF?
My point is, I don't want to, I'm wondering, as it's written, I think it would apply to making the false statement of abuse of neglect to any mandated reporter is what would invoke this. It's not just filing the complaint.
Right.
And I just want to make sure it's being interpreted the same as I'm interpreting it.
I agree, and I think that therein lies the problem, because it's very ambiguous, it's very overbroad, and it'd be very hard to implement as a law enforcement or prosecutor to fulfill that mens rea part of all culpability crimes. I mean, all crimes have that called a mental state. And what is the mental state? They knowingly know that person is then going to call it in for them. So how is there a false report?
Let me clarify this again.
Okay.
So what I'm saying is, let's just say we add the knowingly culpability mental state, okay? And in order to get around this, you don't want a situation where the false statement is not made to the department directly. They just make that statement to a mandated reporter, so that hoping that the mandated reporter files or makes the report with the department to get around it. I'm reading it as if someone were to do that, the person filing it is not culpable. They're a mandated reporter. They suspect what the person's telling them is true. So I don't think they have an issue here. I think this would apply to the person intentionally making the false statement to the mandated reporter. And I'm just clarifying it. Do you interpret it the way I do? I was thinking out loud. My question was not my best work.
No, I do, and I wonder then, so the false report itself is the crime. So the false report to the professional reporter is what's being criminally sanctioned, right? No person shall maliciously or with intent to harm make a false statement to these people. And it includes a mandatory professional reporter. So the crime happens when they tell that, let's use an example, a doctor, that their child was struck by their ex-husband. Then the doctor would call that to law enforcement? Like, I don't know how you would gauge that or enforce that.
Well, the doctor would be mandated reporters, but I understand. So that that doctor, I presume, will file a report with the department. I think the application of this would be the person making, hopefully it says knowingly, making the false statement with malicious intent to cause harm to the doctor. That's where this would apply. Whether a report's filed with the department or not, that's an issue for the doctor on their end, but that's my understanding of the application of this.
Yes, I absolutely agree with you. I'm sorry, I got a cold today and I'm struggling a little bit.
Equally culpable here with the poor questioning.
Thank you for, yes, I agree with you.
Thank you.
Yes.
Sorry about that, everyone. Senator Long.
Thank you, Mr. Chairman. So the of the 1,203 anonymous calls, complaints, 514 was screened in. Do we know of those that weren't screened in? Does DCYF know what would be suspected false reporting?
No, I do not know. And again, just to clarify, a screen in and screen out doesn't mean that it's false reporting. A screen out could happen anytime it does not, taken as true, meet the definition of abuse and neglect. Or it does not meet the definition that rises to an investigation, but possibly would be a screen out, but law enforcement involved, which means that it was an out-of-home perpetrator, so it involved a possible crime to a child. It'd be screened out for DCYF, but could still result in what's called a law enforcement notification, which is required by law anytime there's a reason to believe a child has been a victim of a crime.
So there still can be some screened in false reports or malicious reports. If I call DCYF and put a child in, saying that the child's in danger, they're not about to, this guy's reporting falsely, they're going to screen that in.
Correct. Okay. And that would go to the local DO, district office, for their assessment and investigation.
Okay, and follow up if I may. With respect to contact information, is it first, is that public?
No, so they have the ability in statute to have that what's called reporter not allowed, in which we keep that confidential. At the time of the call, they are made aware that if they choose to remain confidential reporter, there may come a time, if there is police involvement or court involvement, that their name would be required to be released to do further investigation.
Okay, so the interview, if I'm filing a complaint, to interview me after this conversation over the phone, I'll give you my information that you're telling me. I could tell you I want it to remain confidential, so my name and number is for you.
Correct.
And that remains that way.
Correct. Okay. Unless a court order says differently very later on in the process.
Right. Okay. All right, great.
Yes.
Thank you.
Yeah.
Thank you for your testimony and also for answering the questions.
And thank you for your time.
Sometimes. At this time, the chair recognizes Frank Kirtland. Kirtland.
Thank you, Chair. Thank you, members. My name is Frank Curl. I'm from Northampton, New Hampshire. My girlfriend, Stacy Terosian, testified earlier. I'm here to talk about what happened with this police report. We did email you a copy of the New Hampshire Police Department. It explains everything. And along with a letter from Shelby Anderson's attorney threatening us if we spoke out in public that they were going to file legal options against us for slander and libel. We stand here to tell you the truth. We've maintained that. We've told people about that, what's going on with the false allegations. Stacy was doing a lot of lobbying online to get people to talk about this and explain what was going on. There was nothing slanderous or libel about it. We spoke the truth. We even spoke to the officer that took the report, Officer Whitcomb, and we asked him, is there any way that we can file charges against Shelby for making these allegations and everything? Because they found it was unfounded. He said, let me check on it. Got back to us about a week later. He says, there's nothing we can do. It doesn't address it. I said, wait, you're filing a false police report. He says, it doesn't cover the child abuse. There's nothing specifically calling out for that. So then just last week, or when we got the letter from her attorney that you guys have a copy of, we called the New Hampshire, Northampton Police Department, and we asked the officer on duty. We asked for Officer Whitcomb, but he was out on a call. And we explained what was going on. And we read the RSA that was in the letter that the attorney was saying that we should have used, and it's therefore not a false report because we would have used that RSA to file a false report. The RSA was 641-4. And we asked the officer about that. He did the research. He goes, no, we would never use that for this type of instance. So that's one of the reasons we're here, that we support this bill. You guys are calling it out as child abuse for false reports. That's what it needs to state. Just to give you a quick background, I know Stacy did earlier. We've been in a committed relationship for the last 4 years. And then during the time, Stacy talked about her daughter struggling with drug addiction, not only once, not only twice, but constantly. The last time, the kids were placed in her care by DCYF and law enforcement. During that time, the kids came to us in somewhat of a feral, neglected state. Stacy was a grandmother. She set them up with CASA and the other agencies to come in, and they monitored. The kids were thriving. Both children were, she didn't want them going to the foster care system, so she provided a stable, loving home. The girls thrived. Family and friends all supported Stacy and the girls. Numerous days at the beach in the summer, cookouts, school, routines, and time with family. This was a positive example for the girls to emulate. Shelby should be overwhelmed, blessed, and thankful for having her mother, Stacy, in their lives. I fully supported Stacy with this, and we were only dating a couple of years at the time. And she even told me, she says, Frank, you didn't sign up for this. I says, I'm here now. So that was the deal with it. And she's been, now Shelby has been on a dedicated smear campaign filled with absolute bald-faced lies to include the false abuse charges against her mother, per the the abuse claims. We even went to court and provided Judge Cooper with the police report, along with other exhibits that you all have and some other things, right? When he came back with his rendering in a written court order, he even said that he didn't find the respondent credible in her testimony. We thought that was going to be the end of it. We were going through grandparents' visitation. He came out with a scheduling order for grandparents' visitation. He also put in the order that he was concerned that the respondent wasn't going to follow the order. Well, she didn't. It took us about 4 months to get a contempt charge hearing to go in and address this. What happened is when we went in for the contempt charge, there was another judge there after 18 months. There was a judge, you'll probably hear more about it, Judge Bedrick. He ruled against it because her attorney at the time, I guess she was an attorney that does bundling. I'm not really familiar with that. It's only certain, just a case or something of that nature. And she quoted the Cobble Supreme Court ruling, right? And we'll talk more about that on the on the grandparents' visitation. I have some input on that. But needless to say, the case was dismissed. Stacy has not seen the kids in over 2 years. It's still a constant smear campaign. Again, we've been threatened to, if we come in and do public speaking, cease and desist order, they would file. And we're doing this as a public speech. Our speech is protected when we come in here and we testify. Somehow she's trying to work around that, so scare tactic. Other than that, I support this bill wholeheartedly. If there's anything that we can do, please let us know. I'm open for questions.
Seeing no questions, thank you for your testimony.
Okay, thank you.
Thank you for your service as well.
This time, the chair recognizes Kate Shea. Thank you for your patience.
Good morning, Senators. Thank you for having me. Kate Shea, Goffstown, New Hampshire. There we go. Can you hear me? Kate Shea. So I'm here in support of this bill. And by the way, it's so good to see you all up here today. Here supporting this bill. And I wanted to offer a little bit of my testimony, but also I ran a survey. I had surgery last week, so I only could do a 5-day survey, but I got 20 other people to support this bill and write up testimony. So I'll be submitting that to the record as well. So I'm here as the daughter of a public school teacher turned social worker. I'm very familiar with the real stories of abuse and those where people leverage the system and weaponize it against others. I'm also very aware of process reengineering. I'm in that kind of business myself. I understand that resources are scarce and they should be used appropriately. And this is not about process. This is not about DCYF, really. This is about legal loopholes. And we have a legal loophole today. And we have lack of accountability and enforceability. So I just wanted to briefly tell my story. I know you've heard a lot of people today. I'll keep it very short. But this is about a perpetrator, and I presented this to the House a number of times as well. I even drew a diagram showing 12 to 20 people that were all engaged in the plot of a smear campaign by my ex-husband, who engineered it at the start of a divorce. And it's about those who tag along knowingly and acting malicious with intent to harm. And it could be, I think you have to appreciate the context too. It's divorces quite often. It's people that are going through really rough times. It's special education disagreements. All of these put you in the crosshairs and put you in a very dangerous and vulnerable spot, as it did me over a course of 6 years. And the perpetrator continued the attacks similar to how there have been attacks in the marriage. Those perpetrators typically are the same person that will do these things and continue on with the abuse. Whether it's emotional, verbal, or physical. They even continue to do this to hurt me, to ruin my reputation, stress me. Even when I was fighting for my son's life, a child that had a serious brain illness, I'm getting a call in the hospital saying there's been another false accusation. I knew it was false, but it was unfounded after the fact. And even the person making the call said, I'm sorry, we have another one of these to deal with. Fighting for a child's life. And he even made the threats verbally and in writing. One would think you could do something about that, but not in family court. It doesn't go that way. Going back to real harm, it's about the kids of the innocent also. So we heard about Rep. Spillane's son. Also my children and those that are in these cases, these other 20 people, their children are harmed. There's an indelible mark that's left on these kids, whether it's being woken up in the middle of the night or the emotional trauma of seeing their mother, pulled into some conference with some important person that comes to the house that you have to open the door to, and they're terrified, they don't know what's going on. Those are lasting scars. They will never get over that. Even to this day, my children know their own father was responsible for the lies. That's a tough pill to swallow. We all have baggage from growing up, but that's some of theirs. And nothing has ever been done about the repeat callers and the other people of the 12 to 20 people who all decided to gang up on me and try to drag me down, whether it was the school because I was fighting for an IEP, or it was somebody else, a girlfriend, or the girlfriend's kids, or their therapist. They had layers of immunity. And meanwhile, I had no protection at all. And the effect of this, being accused doesn't disappear. It follows the family. It stays in the records, stays in the neighborhood. People talk, whether it's unfounded or not, it's real harm. And similar, as I've shared this with the House before, similar to the story of those of you who recall the Scarlet Letter when you read that in school, if you're like Hester, whether she did something right or wrong, you still go away with carrying this burden for the rest of your life, that you are accused of something that you didn't do. And some of these things being so frivolous as your child looked unkempt. You know, I mean, even the calls that I would get when they would come in, they'd apologize and say, we're really sorry, you got another one of these, you know. So I hope that you hear these stories today and pass this. This is a crime the perpetrator is getting away with and knows it. There are loopholes in these other laws. There's no enforceability. And that is really what's chilling, is to know that in the state of New Hampshire, it's chilling to know that nobody cares that I've been harmed and no one's going to do anything about it. And a host of other people are walking away with that burden for the rest of their lives, and the children of them walking away. That's truly what's chilling here. So please pass this bill. Thank you. Questions? Thank you.
Thank you for your testimony.
And Mr. Z. I'm Robert Tangway. I'm the author of Incentives in the Environment and also Emissions Tax and the book, New Hampshire Oliver Twist, which talks about this. I am not in support of this bill as currently drafted, but I think that if it were to go through, it would be some sort of a step. The problem, I've taken a lot of notes with the testimony, and I want to give a hand for the lobbyists that were asked a tremendous amount of questions and took up a tremendous amount of time, but they're not here right now. That's Waypoint, and they're getting paid. And if you look at it as a business, it's simply increasing the market share. Same thing with the Domestic Violence Coalition. Most children don't get abused. Abuse is rare. And they have to market that abuse is rampant. It's actually pretty trashy, and it happens in mostly lower class families. And so does drug abuse too. And it only gets noticed when a rich kid dies of a drug overdose. But when two parents that are poor, like in Harmony Montgomery's case, which is what we don't talk about, someone goes to the Manchester police and they don't care. And then if you go back to Miller v. Todd, where his two daughters were examined in their private parts for years, and after being accused, as the father was accused, all unfounded, of false reports.
I know some other members of the public testified about false reports, but those false reports applied particularly to them. So rather than discuss a broader nature of I understand, but if we can just stick to the subject matter of the bill in the contents of it.
It's the false reports, because, and so I appreciate that, but again, I'm going to bring it back respectfully, Senator Abbas, that you didn't do that when a lobbyist was on this panel right here. You didn't say go back when there's talking about everything and written testimony, and you asked her a tremendous amount of questions. So Miller v. Todd is a very famous case, and also involving the Manchester police that do nothing.
Excuse me. Again, the statements about the Manchester police, I'm going to consider that out of order. I just ask you, with your testimony, I respect that you have a right to your opinion, but please stick to the subject matter before us involving the bill. I understand your opinion on that, but we don't need to indulge in that anymore.
It's not my opinion, it's the Supreme Court's opinion. So
it's the last warning I'm going to give you.
Well, then you'd be violating.
You may continue.
Thank you, Senator, but you would be violating my First Amendment rights and ability to redress grievances, which is also a violation of the New Hampshire
We'll cross
Constitution.
that bridge when we get there. Please continue with your testimony.
Okay, so as the other people did testify, and I can testify in my own case, is I went to the police. I called them. I have the police records. And actually, all three of you have received a letter from me with a picture of the criminal defamation, which that's what a false report would be, is a criminal defamation. And haven't really done anything about it. And I don't think that you guys are bad people. I just think that you're in it for your own reasons, politically, and I think there's a lot of fear of what happens when you go against the grain. Now, if you're talking about, so the main reason why this bill shouldn't be passed as written is because it has no teeth. Attorneys, under the penalty of perjury, RSA 311:6, must report judicial misconduct. Doesn't say that specifically, but it says to let no untruth and correct truths. So they don't follow that. They don't follow perjury. They don't follow unsworn statements. The police are and these are all crimes. Child abuse is crimes. So just like domestic violence, 173B, all acts, they can call it an act, but a pickle is still a cucumber. An act is still a crime. Therefore, the police must prosecute, or they're holding someone outside the protection of the law. But what you're really going to find is that you can write all the laws you want and create all the penalties, but it is up to the prosecutor to prosecute. And then I called the police, and because the mother of my children was at one point having an affair to a married police officer, we were left, and then took my children out of state, which is 633:4. They didn't even take reported. So I think that this bill needs teeth as far as failure to prosecute and failure to investigate, because they don't have failure to investigate is different than failure to prosecute. So they're not even investigating. The police aren't even investigating reported crimes or child abuse. And so I think that when you hear people's specific stories, it kind of goes out of, it's boring to people. They don't care. They care about the systemic issues, and you should too. And that's why you seem to ask so many questions of the lobbyists, because they're talking about systemic issues, but they're lobbying for more grant money. That's what they're doing here, and that's why they wear little red buttons.
Excuse me.
Yes.
Listen, to say that about that a lobbyist, whoever, who's already testified, and to assign that type of intent to them is inappropriate. So please, that's not going to be tolerated any further as well. You can continue with your testimony, but no, I am going to, last warning, do not assign intent to any member or any member of the public, whether they're a representative, whether they're a senator, whether it's just a member of the public or a lobbyist, to suggest their motivations, unless it's related to the actual testimony they provided. To suggest it's for financial reasons is not appropriate.
Okay. Well, you would concur that wearing a red button, as required by law, indicates that they are being paid to speak here. Would you not? So I can limit to that.
It's an orange one, but I understand.
Oh, orange. I'm sorry.
I think it's pretty well known that many lobbyists are paid, so we don't need to discuss that any further. Please
Right.
stick to the content.
Thank you. And I don't mean it to, okay. So they mentioned the chilling effect, and that's their testimony and the chilling effect. But again, I want to bring it back to the systemic problems, the silver bullet. I call it the civil bullet. So what we're having is the police have actually a very low standard to get a warrant. It's probable cause, right above a suspicion. When you go into court for a DV civilly, it's a preponderance of the evidence. And if you review documents submitted by the Domestic Violence Task Force and the review of the Judge Pauly case with Lindsay, you'll find that they know that domestic violence and what's actual abuse. And they know the case law, but they don't do anything about it because they make a lot of money off of
All right.
litigation.
Okay, at this point, we've heard enough. Again, I gave you several warnings on that. I'll let you-
Warnings on
At this
what?
time, I'm gonna ask you to close out your testimony, you may conclude, but
Okay.
again, I'm applying that type of intent to the court and not gonna be accepted when testifying before this committee.
Well,
So you may conclude your testimony.
Okay, so I'd like to conclude people are saying, and that there's a perception that children don't know, they can't report anything. Well, let me tell you a personal story that I've thought about very much so. When I was 4.5 years old, a man tried to molest me. He told me if I closed my eyes and sucked his thumb, that I would get a Keebler cookie. I was smart enough to know that he would not, and I opened my eyes, and there before me was the attempt of molestation. I went and told my babysitters, and then my first time in court was 5 years old. Children know what's going on, and they shouldn't be harassed by false allegations. Making someone a mandatory reporter that is not a government official or sanctioned by the government, licensed by the government, I believe is unconstitutional. But I guarantee that anyone in this room, any decent human being, if they saw any child abuse, anyone, myself included, would stop that abuse immediately. But it doesn't happen as much as we're admitting. And that's what we need to do. You can pass this bill. I think that you should pass this bill. But there's laws that aren't being followed because nobody's prosecuting on them, and the police will. So you need to add teeth to have the police prosecute on this. And then I also think that as the Honorable former Representative Betty Gay said, line 10, Department may, shall. It should be changed to shall. It shall to meet Article 15, right of the accused. I am sorry that you feel that I may have crossed the line, but it is very important that these things happen. It does not matter. You cannot do anything in my case unless you remove justices from the Supreme Court.
Thank you for your testimony.
Do you have any questions?
Thank you.
May I ask a question why you don't have any questions of?
It's not appropriate to inquire of the committee of questions. The committee is asked questions to the members testifying. So.
Senator Abbas, Article 8 of the New Hampshire Constitution requires the government to be responsive. So if I ask you questions, you should be responsive. But I can't make you do anything. So I ask that you do consider my testimony and any documents that I have or will give you and take a hard look at it, because I think that you are trying, and this committee is trying to make the world a better place, but they're not giving enough weight to actual people that have knowledge of actual events.
You concluded your testimony already. Thank you again. Are there any members of the public present who wish to testify that have not testified already? I see 2 representatives raising their hand. Would you like to come up together?
Thank you, Mr. Chair. Sorry, I came in late. I was testifying on another bill. For the record, Kelly Potenza, Stratford, District 19. You've heard a lot of testimony. I'm going to keep this very brief. When I first ran for office in 22, I became a rep in 23. I received a phone call from a father, and that was in about May of 23. And his story was just atrocious and begging me for help. And there was not really much that I could provide for him. And it was our laws didn't protect him, didn't protect that false reporting piece. This was a man that had 3 children, has 3 children, and went through a pretty awful divorce, disabled veteran. He had gone through
By the time he called me, 5 different allegations that were all unfounded. Every single time he had gone through 3 attorneys. It was just the amount of money. I just couldn't, and there was no redress of grievance for him. And the thousands and thousands of dollars that he just didn't have. And so we've got to fix this. When it comes to anything that has to do with children and abuse, everything should be swift and certain, 100%. But it should be on the other side too, because that other form of abuse, whether it be to a parent, also impacts those children. And from that initial conversation, which he started sobbing pretty much uncontrollably, and get choked up just hearing it, he said his son didn't want to go to mommy anymore because mommy hates daddy. And that came from like a 6-year-old boy. And that is abuse. So however we can make this bill what it needs to be, however we can make it better, prime sponsor already said that, I guess, at the beginning of his testimony. Let's do this. Let's do this for all of the people of New Hampshire that have been waiting for this type of pathway and justice for a long time. Thank you.
Representative?
Representative Timothy Horgan, Stratford County District 10. First of all, I was one of the, 165 reps who voted for the ITL motion, basically because I thought the bill was unnecessary and counterproductive. So, these family, especially these family law cases, they can be very, very painful and complicated, and usually there isn't necessarily one side that's right and one side that's wrong. Often, both sides are partially right and partially wrong. I raised my hand just because there's a case that I hadn't thought about in several years, but which did come before a House committee, which did come up during the proceedings of a House committee which no longer exists, which was the legendary Miller versus Todd case. And I just quickly glanced at the decision, and my recollection and impression is actually Mr. Miller, the petitioner, James J. Miller, who was a father, and Todd was the mother. He actually won his case, but there were some pretty disturbing allegations. I've actually, a number of years ago, actually did look through the whole Supreme Court case file on it, which my subjective impression was about that one. We're not really here to relitigate that case. Is that they were kind of everybody's a little bit too harsh on the mother, so they were very eager to believe that she was a crazy woman who was just making stuff up. And so that particular case, I was a member way back when Bill O'Brien was a speaker, so that was 2011 through 2012 of the Petitions and Redress Committee, which was a short-lived experiment that didn't work out too well. And so the Miller did not bother to file a petition, probably rightly so, because he actually won his case. He was fortunate enough to have a lawyer, so it turned out better for them than for most of the other. But there were some other parents who, rightly or wrongly, were in a similar position to him, who had less luck with the legal system. And I think two of them were connected to Dr. Miller because they had the same marital master named Philip Cross, who we actually tried to bring a bill of address against, which didn't go anywhere. In fact, ironically, he soon afterwards became a district court judge. So, and I guess there are probably files up in the House Clerk's office, which relate to those petitions if you think the Miller versus Todd case or the related case are relevant to your decision on whether or not to consider the bill. Although I personally just think this bill is unnecessary. It doesn't do anything to solve a problem, which probably is not beyond the power of even the New Hampshire House or New Hampshire Senate to solve. So I would So in terms of what's sitting in front of you, I respectfully think the majority of this Children and Family Law Committee, but the minority of the full House, I think we made the right call in finding the bill inexpedient to legislate, and that's what I would recommend this committee and the full Senate do. So that's my testimony. So wasn't planning to speak, but sort of like the mention of Miller versus Todd, like made me feel like it might be useful to get up for a couple of minutes and speak. So that's my testimony. So thanks.
Thank you, Representative.
Yeah, so ITL is my recommendation.
Are there any members of the public who are present who wish to testify that have not testified already? Is there any? The floor is yours. Is there anyone in the hall?
What time do we?
Gail Probett for the record, New Hampshire. Isn't it? Red's on, okay, sorry.
Red is on.
For the record, Gail Drobet, Amherst, New Hampshire. I am in support of this bill. There's too much potential abuse and neglect of children in this state. We just heard on the news yesterday, another 12 children have died in the past year. It's got to stop. We need your help. We got to get good bills passed to protect everybody, the false reporters, the real reports of abuse and neglect. We got to get this passed. Everybody needs to be protective. If there are allegations, there needs to be assessments. You need to assess for both parents on either side. Either one is lying, which needs to be assessed out, or the other one's lying and there is true abuse. It's got to be, these children have one childhood. We are begging you. I've not personally been in the court system, but I hear stories every single day. I've been up in Children and Family testifying for years. That committee's beyond repair, unfortunately, but we look to you, senators, praying you can help us. That's all I got to say. Pass it, please.
Thank you. Are there any members of the public who are present who wish to testify that have not testified already? Seeing none, we will now close the public hearing on House Bill 243. The
3-minute break.
the committee will be in recess for 5 minutes.
Thank you.
At this time, we will now open the public hearing on HB 320.
Just us? Here we go.
The floor is yours. I don't have a list. I probably do. I can't. Oh,
Let's exact things.
it's literally in my hand. I'm sorry. Representative DeSimone, you're recognized. And just going forward for this and all other public hearings, we're going to limit testimony to 3 minutes.
Well, I'll be sure to keep it more brief than that, Mr. Chairman, and thank you, Mr. Chairman and committee, for allowing me to speak before you today. For the record, Deborah DeSimone, District 18, Rockingham, District 18, Atkinson. I come before you today to introduce House Bill 320FN on behalf of the sponsor, Representative Mark Hall, who is also from Rockingham 18. He has sent me a little bit of testimony for you and stating currently there is no requirement that a court enforce its own orders. As a result, a party can lose out on property settlement if a court simply chooses to not enforce its own orders for no reason at all, and this is not an appealable matter. It's a right. The bill applies well-settled legal standards that form barriers to enforcement. They're listed in the bill. This is needed. It's a solution to a serious problem and a big hole in the system. The barriers to enforcement are listed. They include fraud, misrepresentation, illegality, etc. I just would like you to note that it allows courts to fashion remedies to put the parties in the position as if the orders had been fully performed. This greatly helps self-represented parties to figure out their cases. We know that there are a multitude of parties entering the courthouse pro se. This bill will assist those pro se litigants. I thank you for hearing me.
Senator Long?
Thank you, Mr. Chairman. So is it the intent to go back on settlements and decrees? Even if this were to pass, I could go back to my decree that was 20 years ago and bring up issues from that? Is that the intent?
No, it is not.
Okay, so
It is the intent to be able to do that during an ongoing case,
follow up.
as far as I know.
Recognized.
So would it be all right? Would you be open to adding, 10 years, a settlement or a decree, 10 years?
Considering that I'm not the sponsor, I would respectfully request that since the sponsor cannot be here today, that you might want to contact the sponsor and ask him if he is amenable to that.
Okay, thank you.
Thank you.
Seeing no questions, thank you for your testimony.
Thank you, Mr. Chairman.
At this time, the chair recognizes the Honorable Betty Gay.
Thank you for taking my testimony. This bill is highly necessary. I'm sure nobody thought originally when laws were written that there would be a problem enforcing what a court ordered. However, that has become extremely common. So not only in marital property settlements, but we see this in court orders for custody all the time. And what we're finally learning is that the county sheriffs are counting on certain words being in a decree. It turns out you have to say that you can take the child by force if the other parent refuses to give up the child. I don't like the words, but that's what they say works. So it looks like the efficiency is put that in your original order. And to me, it looks like this bill does that. It says if you've got the decree, you're going to fulfill it. You're not going to make the person, but it sounds like you do have to come back and say they're not doing it. So now this bill says they have to do it. And if you don't do it on your own, the judge will do it. So I think this is really a very good law to add so that the court decree is actually held up is that the right word? Upheld. And I thought that was a good catch about Delta T. How long do you let people appeal? So I'm sure that can be added in as a really simple amendment.
Are there any members of the public who wish to testify that are present that have not testified already? Seeing none, at this time we'll now close the public hearing on House Bill 320. At this time, we will now open the public hearing on House Bill 478. And at this time, the chair recognizes the Representative DeSimone.
I'm the sponsor of the bill.
You're the sponsor. You may take the place or testify in addition to.
Okay.
In just
My
for the
good colleague.
Purposes of this hearing, we are limiting testimony to 3 minutes.
Sounds good.
Thank you.
Well, thank you, Mr. Chairman and members of the committee. For the record, I'm Representative Peter Petrino. I represent the town of Milford, and I serve on the Children and Family Law Committee, the House Children and Family Law Committee. And I present to you House Bill 478, which establishes a permanent foster care oversight subcommittee within the Oversight Commission on Children's Services. Now, this is bipartisan legislation which came forth from Senate Bill 566, which formed a committee to study foster care families and the foster care system. This past summer, Representative DeSimone, myself, along with Representative Alicia Gregg, and chaired by Senator Shannon Chandley, met from August to October. We held 8 various meetings, and we heard testimony from DCYF. We heard testimony from the Office of the Child Advocate, Children's Law Center on Waypoint, and current and former foster parents. And they reported feelings of isolation, loneliness, children's needs not being met, lack of support, dysfunction with the agency. And so after hearing this testimony over the summer, our conclusion was that it would be best to form this permanent subcommittee. And so we bring it to your attention and ask for your support. And I'm happy to take any questions. Yes, thank you.
Thank you, Mr. Chair. Thank you for taking my question. So my only question is, the House bill has taken out the Office of Child Advocate. So where would that fall? If that stands, where would this fall?
Well, I mean, that hasn't occurred at the moment, so we're dealing with this particular legislation as is. We can't look to what may or may not happen down the road. This piece of legislation right here stands on its own merits. So
All right, thank you.
okay.
This time the chair recognizes Representative DeSimone.
Again, it's a busy day for you today to have to listen to me. My name is Deborah DeSimone. I represent Atkinson, Rockingham 18. Thank you, madam. The only thing I really want to add to this is I do also and have for many years with Senator Long serve on DCYF. advisory board, and we actually had the director of the foster care unit come in and speak to us. And it solidifies the reason that this bill really should be passed, because to have an oversight committee will assist the foster care program into learning what they need to do to recognize the needs of all foster care children. There is a great need for foster parents for teenage kids. And many foster care parents don't know how to parent those kids who unfortunately come from very difficult backgrounds. So I think that this oversight committee can really assist the foster care program, and it's very necessary. And I won't get into everything else that Representative Petrino so eloquently stated. So thank you for hearing me.
Thank you, Representative.
Thank you, Mr. Chair.
At this time, the chair recognizes the Honorable Betty Gay.
I really appreciate, thank you for taking my testimony. I really appreciate all the people who worked really hard to put this bill together. It's really seriously needed. We found out in listening to people's testimony about all things considered of family court, family issues. People feel often very isolated, not supported. They're dealing with really difficult issues. Children who've been harmed and are in foster care often have extra problems, more so than just a regular parenting challenges. And so, again, I think it sounds like creating an advisory board would give some teeth to people who say, you know, we recognize there's some problems and we think there really ought to be some changes. Whereas if you're just an advisory board, you can say, well, here's the problems that we see. But I'm hoping that it means that the oversight committee can actually affect change. So yes, there's a serious need. The people who are doing these services, providing these services, need all the support, deserve all the support, and I think this will give it to them. So thank you.
Thank you, Representative. This time, the chair recognizes Robert Tangway. At this time, the chair recognizes Emily Lawrence.
I didn't intend to sign in to support. Sorry if I checked that, or to testify. Just to support.
This time, the chair recognizes Cassandra Sanchez.
I'm still here.
Yep.
Good afternoon. Attorney Alyssa Mascio with the Office of Child Advocate. Cassandra had to step out to another meeting, but we are here in strong support of this bill. We supported the bill last year and actually participated in every one of those study committees over the fall. Foster parents are a group that we work with very closely at our office. We receive a lot of calls from them. We also will work with them. They have groups as well. And the testimony that was solicited at that study committee, in part from calls of action from our office, was very compelling that this is an issue. We know that DCYF is working on this issue. They have made some changes to the caregiver coordinator unit and some of the other foster care recruitment and retention, and we hope that work continues. But the work that the Oversight Commission on Children's Services does, which Senator Sullivan sits on, is very important and crucial. We thought that would be a great place for this subcommittee. Senator Carson also happens to be the president of New Hampshire FAPA, which is the Foster and Adoptive Parent Association. So she also has very direct ties to that community. So we thought the level of knowledge on that committee was really important. I think this does, though, point out the importance of the work of the Commission on the Oversight of Children's Services, and that with the repeal of 21B, that commission would disappear along with our office, which also does a lot of really important work in this area. I'm happy to take questions. Thank
Seeing
you.
none, thank you for your testimony. Are there any members of the public who are present who wish to testify that have not testified?
Good morning. I thought I signed up, but I probably did it wrong. Excuse me, sorry.
It may be my neglect here.
No, that's okay. Thank you for allowing me to speak today. My name is Lori Corzin, and I am the state representative up in Coos County District 7. I am here today to speak in support of the bill. I think that Representatives Petrino and DeSimone and Nelson did a great job, and it is something that's needed. I stand, sorry, I'm nervous.
It's just us. Take
Don't
it.
be, and you
Okay.
did, and just so everyone knows, you did sign up to, and you also checked off the box that you wanted to speak it, and I checked you off before you testified, so
You're
That's
already doing better than him.
excellent.
you're doing great.
Do you want to switch seats? 'Cause
Maybe.
my husband and I were foster and adoptive parents in the state of Massachusetts for 15 years. That's where we met our sons. We fostered them for about 2 years before we adopted them. And I've seen firsthand the profound impact a well-supported foster care system can have on vulnerable children. We were able to work with several agencies and dozens of individuals over the course of our 15 years. However, 3 years ago, we were called to become foster parents here in the state of New Hampshire, and we were shocked by what we found. In New Hampshire, we encountered a system stretched thin, where foster families desperate to help are too often left unsupported and undervalued. The state is in dire need of foster homes, yet we keep losing them, not because of a lack of willingness, but because of how families are treated. Inadequate communication, insufficient resources, and a lack of accountability erode the trust and commitment of those who step up to serve. My husband and I experienced this frustration ourselves, and it's a story echoed by many others. HB 478 offers a critical solution, a dedicated subcommittee to oversee and strengthen our foster care system. This body can ensure transparency, address systemic shortcomings, and prioritize the needs of both children, foster families, and kinship families. I believe New Hampshire's foster care system can be a model of excellence, but it needs focused transparency and accountability to get there. I would be honored to volunteer my own time to serve on this committee, bringing my own years of experience to help make that vision a reality. Thank you for considering this vital bill. Together, we can build a system that truly serves our children and supports the families who open their hearts and homes.
Senator Sullivan, you're recognized.
Thank you, Mr. Chair. Thank you for taking my question, and thank you for opening your heart and your home to foster children. I sit on the Oversight Commission for Children's Services, and we recently had a report from the foster care system that they've taken some steps to address some of the concerns that you have. How long ago were you in the system, or working with kids in the system?
About 3 years. 3 years ago is when we took the little guy in, and he went back home about 18 months later.
Okay, I asked that because these are recent implementations.
Yes.
So I'm not saying that this
Yes.
wouldn't support that work too, but I was just curious. So
Yep.
thank you very much.
Not a problem. Thank you.
Seeing no questions, thank you for your testimony. Are there any members of the public present who wish to testify that have not testified already? Seeing none, at this time, we'll now close the public hearing on HB 478. Before we move on to the next, can we stay in here after 1 o'clock? So there's no one coming in. Number 2, so I have judiciary at 1, but at the same time, it's right there.
Yeah.
You can stay.
I can stay.
All right.
But let's keep it limited to the 3 minutes because we've got a lot of people.
Oh, most definitely.
Okay.
At this time, we'll now open the public hearing on HB 486. And just to clarify, we are limiting testimony to 3 minutes per person. And is there someone signed up to introduce the bill? Representative Joey Nelson.
Thank you, Mr. Chairman, and thank you, Senators. Nice to see you today. A constituent of mine brought to me her struggles with her attempts to be granted grandparent visitation, which resulted in multiple hearings, visitation granted, contempt not being addressed, and a reversal of the order issued by a new judge assigned to the case in the final hearing. And this ordeal was over the course of 2 years without any contact with the grandchildren, despite the initial visitation order. And this prompted me to start researching grandparent visitation law in our state, which is RSA 461-A:13, and speak with other grandparents and people from organizations who help grandparents and attorneys. And there were some consistent themes that coming up, and I realized that there were some changes to current law that needed to be made, specifically adding more clarifying language to the circumstances resulting in the absence of the nuclear family and to the nature of the relationship sections of the RSA. I tread very lightly because of my respect of parents' rights and did not want to encroach on those rights. I was relieved and very thankful that two very active and influential parents' rights supporters signed in support of the bill when it came before the House Children and Family Law Committee. So what did I do with this amendment? First thing I did was added the wording separate living arrangements to circumstances to supplement the circumstances of divorce. As we know, divorces can take years, and it's not in the best interest for the child to wait years to continue a relationship with the grandparents. This could interfere with the frequency of contact consideration, depending on the interpretation of the definition of divorce in this instance. It seemed like it was very inconsistent in certain rulings. Sometimes divorce was defined after the final decree, sometimes during the course of the divorce, and some variations within that too. So that's the first part that I wanted to amend. The second has a lot to do with the research that I had done on grandparents who have been granted temporary guardianship of their grandchildren. And we have a lot of them here in New Hampshire. I've seen estimates up to 12,000. And we know a large contributing factor to this huge population of grandparents raising grandkids is due to parental drug abuse. We all know that we have a really big problem here in New Hampshire with that. Many grandparents have temporary guardianship of their grandchildren for several months, 6 more at a time. And when the goal is often reunification, and we hope that reunification with the parent or parents is permanent and successful, we all know that the reality is that recovery can be bumpy. Grandchildren can be going back and forth from parents to grandparents as their parents are battling their addictions, and maintaining a positive relationship with grandparents is crucial to the well-being of the child in situations like this. And this is the main reason I have added the language in lines 15, 16, and 17. This language is in current legislation in other states, and it seems to be working. Lastly, I found an article and a help guide for grandparents entitled Help for Grandparents and Kinship Caregivers Impacted by Opioids or Other Substance Use Disorders. It talks about understanding attachment and bonding, and I wanted to quote a portion of this article that does a great job explaining why the changes in RSA 461-A:13 are important. Young children need to develop at least one relationship with one primary caregiver for healthy social and emotional development to occur. Children become attached to the adults who are sensitive and responsive to them and remain consistent early in their lives. This person is their secure base. Children who experienced a parent's substance use disorder may have felt abandoned due to their parent's absence or lack of attentiveness to their needs. Children who have been removed from their birth parent and go to live with their grandparent or kin caregiver develop an attachment to them. The total loss of that attachment person can cause anxiety and grief in the child. This is why it's critically important that unification planning for the child must include mechanisms to continue at least one relationship with with a bond with a grandparent or kinship caregiver, while at the same time strengthening the parental bond. This should not be a them versus us situation. And with that, I hope I've communicated the need for these changes, and I'll be happy to take questions.
Seeing no questions, thank you for your testimony.
Thank you.
This time, the chair recognizes Representative DeSimone.
Thank you for the final time, Mr. Chairman and committee. Representative Deb DeSimone, Rockingham 18. I just want to give you a couple of perspectives of this. I'm a grandmother. I have 4 grandchildren. 2 of those grandchildren I nannied from birth. Were anything to have happened to their intact family, it would devastate my grandchildren to not be with their nan. 2 to 3 times a week, I get a telephone call from their mother or father saying, "Can you call Nan? I miss her. I need to see her." I see those children almost every other day now that they live in another state. Again, if anything were to happen to the marriage, for me not to be able to see those children, or those children, more importantly, not to be able to see me, would devastate the child. I think that we need to continue to be raising healthy children with healthy people in their lives. And when we have families who do not have a healthy life because of addiction issues or any other issue, it's really important to have a kindred person in their life that they have already bonded with to give them that sense of family. That's what children need. That's why this bill is so important. Thank you so much for your time.
Thank you, Representative. At this time, the chair will recognize. This time, she didn't check out. Lori Corzin. This time, you didn't check the box, but do you wish to testify? At this time, the chair recognizes Stacy Tarosian. And if you want to testify together, I know it's, you each can have 3 minutes, but if there's overlap.
Okay, great.
Maybe we'll just make this, you guys a collective 6.
I just want you to see,
Without objection, please.
I want them to see the children that this is affecting. Good morning, Mr. Chair, Vice Chair, and Senator Long. Thank you for listening to my testimony. I did share some of this earlier. My name is Stacy Tarosian, and I'm from Derry, New Hampshire. I'm here as a concerned grandmother to support House Bill 486 for grandparent visitations. So my granddaughters have been alienated and isolated from myself, my entire family for over 2 years now. And my daughter has manipulated and poisoned their impressionable young minds against me. After 18 months of litigation, that my case was dismissed due to the current legislation, especially in Section 1 of the current law. This language weaponizes bad parents against good, loving grandparents like myself who seek visitations with good cause and concern for the safety and the well-being of their grandchildren, particularly in situations where there is a genuine risk of abuse and neglect. Most grandparents seek visitation as a way of providing a lifeline to the grandchildren in case of adverse circumstances, and the children needing to be reunited with their grandparents once again. Well, Judge Cooper in Manchester District Court granted me visitations at 2 separate hearings in which my daughter would not comply with. In August of 2024, we were scheduled for a contempt hearing for non-compliance of his visitation orders. As I walked into the courtroom, I was ambushed with a new judge in the court, Judge Bedrick, who I've never seen before and who I believe was not familiar with this case. And my daughter is now represented by an attorney who presents me with a motion to dismiss that I had never seen till that moment, and I was not given my 10 days notice or time to even appeal it or a chance to really read it, my contempt hearing has now become a hearing to dismiss my case. After 18 months of litigation with Judge Cooper, he was no longer hearing our case. Judge Cooper knew the extenuating circumstances of this case, including the history of child endangerment, neglect, drug and alcohol abuse, assault and battery, domestic violence, and mental health issues, along with 2 incarcerations in which I was the primary caretaker of her children and many DCYF assessments. In 2019, when my daughter separated from her husband, my daughter and my granddaughters came to live with me for a year and a half. My daughter has always struggled with substance abuse and mental health issues. Well, during that time, my daughter became incarcerated for child endangerment and domestic violence, and I became the primary caretaker of my 2 youngest granddaughters, who were only 1 and 2 years old. At this time, my daughter lost custody of her eldest daughter to her father, but she would come spend almost every weekend with me and her sisters. My daughter to this day does not have custody of her eldest daughter, who will be turning 13. After my daughter was released from jail, she moved into an apartment upstairs from me with my 2 youngest granddaughters, so I could be close by to help with the girls and be a constant source of support for her and the girls. Well, 2 years ago, my daughter invited a drug dealer whom she did not know over to her house while her 3 young children were sleeping, and she suffered a second overdose on heroin laced with fentanyl, with all 3 of my grandchildren present in the home. And as a result, DCYF now places the girls in my custody again. I was the only one that was willing to take the girls, and if I did not, they would end up in the foster care system. After providing 8 months of care, during which the girls showed remarkable improvements in their health, and they were happy and thriving in my care, I continued to work with the guardian ad litem and DCYF, and I also supported the reunification of my daughter with her children. Immediately following the reunification, my daughter, who is still separated from her husband, now restricts all contact between me and my granddaughters. And I immediately filed a petition with the court for grandparent visitations. My daughter retaliates by intentionally and maliciously filing a false report of child abuse to DCYF and the Northampton PD in order to use this against me in court for my grandparent petition. The case was investigated with DCYF's cooperation and was unfounded and closed. DCYF caseworker stated to the investigator that my daughter wanted me to have consequences for receiving one of the children's disability benefits when I had custody and for claiming them on my taxes. The DCYF caseworker also testified in court in my favor of a continued relationship and visitations with me and my extended family, and stated the girls were in a safe home with me. Judge Bedrick, based on his interpretation of Section 1, because he was the new judge now.
If I can just make a reminder.
Okay.
Limited to 3 minutes, I kind of said both of you 6.
Okay.
You've been testifying for 3 minutes, so we do have your copy of your written testimony, though. that you provided.
So you want me to stop?
No, I'm just.
Oh, okay, I'm almost done.
Senator, mine's gonna be just
Yeah.
a short paragraph.
Okay. Stated because I was restricted, this is where it gets, I was restricted prior to the absence of the nuclear family, like it says in section 1 of this RSA, that I have no standing to ever see my grandchildren. And he had no power to grant me any visitations, and he dismissed my case like that. So, and again, that was his interpretation after 18 months having a hearing with Judge Cooper and a final order and a visitation schedule. My daughter just refused to comply. So now this was a contempt hearing and it just gets dismissed, all on the basis that she was not divorced yet on paper, but she was separated. I witnessed the births of all my grandchildren, and I've been a vital part of their lives. I have no recourse now to ever see my granddaughters again, not with the current law, the way it is. And there's no one there to protect them. And when people are under the influence of drugs and alcohol, they don't want anyone to have access to the girls, because the girls may accidentally or say something that they should not say to me. And then the parents could get into trouble again. She also went and terminated the father's parental rights as well, so I couldn't seek visitations through him. So, but I miss my granddaughters, and this isolation and alienation is not fair to them at all, myself or my family. My daughter's not mentally well and has been manipulating their impressionable minds, exposing them to psychological damage by brainwashing them against me, making them believe that I harmed them when I had them all. Also, she could block me from any court visitations, knowing that the court granted me visitations. The girls may unknowingly share information on what's going on in the home, and it could get my daughter into trouble. This is another reason why she doesn't want me to have access to them. I have a lot, but I know I don't have time. But I was a grandmother for 13 years. These girls lived upstairs from me. It was up and down, taking them to the pool. And I had a meaningful, loving relationship, and we had a very special bond together. And she ripped them away from me. And not only hurt me, but it hurts them. It's been over 2 years, and people say, how are your granddaughters? I have no clue. I have no clue. Nobody has any clue. Nobody gets in that house. I have no idea how they are. I'm sorry.
That's okay. So I'm Frank Girl, and I'm Stacy's boyfriend. I just have I'm the oldest of 17 grandchildren, both maternal and paternal. This is the first time I've ever heard about grandparents' visitation. Normally, if somebody was holding grandparents' visitation, it was a family meeting. I mean, it was an intervention. I've never heard of this until this popped up. I didn't even know existed. So when she applied for this during the court and everything, we went through the whole 18 months and everything. Her lawyer at the time whipped out a motion citing Cobble versus Cobble. And we're like, what the heck's that? So the judge on the final hearing with Stacy, when she walked in there and got ambushed, the judge made a statement. He goes, I know all about this law. Mm-hmm. You know, we're like, she's like, what the heck is that? So what he did is he started asking her questions. What was the date that you were restricted? Was the daughter divorced or not divorced, kind of thing? So Stacy tells the judge like that. And he says, well, you have no standing. It's dismissed. And that was it. And we were like, what the heck is Cobble Cobble? So I pulled it up, and I'm reading it, and I'm like, the attorney of record was Jared Bedrick, the same judge that just ruled on this. I'm like, he can't do that. That's a conflict of interest, man. He should recuse himself, in all honesty, right? But he did it kind of smugly, walked out, and that was it. So the Cobble Cobble case, not only did that judge, he was the attorney of record that filed the appeal and was successful in it against Herb and Lori Novell, right? And they can give you a whole, you've got their statements and everything else. This lawyer was actually in the wedding party of Cobble Cobble. I'm like, it doesn't stop. It just keeps going. So what happened was we asked to, hey, reconsider the case and have Judge Cooper here because he was familiar with it. Judge Bedrick goes, no, absolutely not. It's done. So that was it. Now, I just have one suggestion on the law since it's Cobble Cobble because there are 6 grandparents that the Cobble Cobble case impacted that the court used against them to strip any kind of visitation. So reading that Cobble Cobble case and the decisions of the district judge, by the way, I can't see how one judge is doing the case for almost 18 months and another judge gets inserted in there one time and just, it doesn't make sense. To me, anyway. But the grandparents, so Section 1, if you look at Section 1 on the bill, it says the second sentence line where it says the provisions of this section shall not apply in cases where access by the grandparent or grandparents to the minor child has been restricted for any reason, any reason prior to the contemporary with divorce, death, relinquishment, or termination of parental rights, or other cause of absence of the nuclear family. What that did was the judge doesn't care what reason it is that you restricted access to the kids. He's not concerned about it, or she's not concerned about that. Did you restrict them? Yes. Why? It doesn't matter. It doesn't come up. Well, wait a minute. She wants money off of Stacy, right? It's an extortion kind of thing. You don't give me the money, you're not going to see the kids. So she doesn't have to tell the judge what reason. All she has to do is restrict them. So my proposal to fix this law, to give it a little more teeth, is to strike that language there and get it out of it. Now it's going to be on an even ground. Now the needle's going to move from parent back to Centerline. You still have constitutional rights for the parents. You still have that, everything, right? But this is going to be based on merit. And what happened, the history. She had a loving relationship with those kids. Those kids loved her. And now all of a sudden they're going, so what are you going to do? You're going to tell the kids, you can't sit there asking, where's Mimi at? So what are you going to tell the kids? Well, the provisions of this section shall not apply to cases, blah, 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 you know, the dissolution of the marriage, you know, prior to the nuclear family. They don't care about that. They want to see their Mimi. Whatever the issues are that their parents have with the grandparents, as long as it's not abusive, it's nothing out of the ordinary, it should be moot. Those kids are being penalized because the mother has an agenda to go after money and cause pain and, you know, hate and I'm sorry, it's just, so that's my suggestion. I appreciate it.
We're not the best at keeping time in this committee, as you can tell, but.
I
When
apologize,
you have
sir.
a passion for something, you kind of want
I
to get it all
understand.
out and get it
Just
all out.
my suggestion, Senator.
That's why we're negligent with the time, but
Thank you, Senator.
Thank you.
Thank you all.
at this time, the chair recognizes Deborah Samar. Friendly reminder of the 3-minute time warning.
Thank you, Chair.
No. Hit the silver.
Red means go in these.
Thank you, Chairman Abbas and members of the committee. My name is Deborah Smar, and I live in Bow, New Hampshire. I'm here today to testify in support of House Bill 486 FN relative to grandparents' visitation rights. My husband and I have 3 granddaughters, ages 11, 8, and 5. Our son and daughter-in-law and their growing family lived in our home for almost 3.5 years while they saved up and eventually bought a house in Chichester. We have always been in constant contact with them, seeing them weekly, FaceTiming or messaging several times during the week. We always attend and support their extracurricular activities, have them for sleepovers, often when their mother requests to give her a break. We've rented houses on the Cape and Lake Winnipesaukee so our families can be together for vacations, all to create memories for our grandchildren. Last August, after a long time coming, everything fell apart in their marriage. Our son was arrested and a restraining order was issued against him. He has not seen the children since that time. We've continued to support our daughter-in-law and grandchildren emotionally, spending any time we can with them. In early November, we had the 3 girls over for a sleepover and everything was great. We were supposed to have them for our family Thanksgiving, and that morning our daughter-in-law informed us that the girls are not comfortable with us and she would not force them to see us. She ignored our request to have them for Christmas, which we were previously told would be fine. We've gone to our granddaughter's basketball games, and now the girls will not look at us or speak to us. Our granddaughters are being alienated from us. We have never said a word to them against their mother and only have their best interest at heart. We are trying to obtain visitation with them to repair the damage that has been done to our relationship. However, as the law is written now, we have little hope of that happening until the divorce is finalized, which could take months to years. Outside of their parents, my husband and I have been the most consistent and supportive presence in our grandchildren's lives. We respectfully ask that you find this bill ought to pass to amend the criteria for grandparent visitation. Thank you for your time.
Thank you.
Thank you. The Honorable Betty Gay.
Thank you very much. And yes, 3 minutes is plenty of time to say all the basic things. It was already pointed out to you on lines 5 and 6. The provisions of this section shall not apply in cases where the grandparent or where access by the grandparents to the minor child has been restricted for any reason. I think that any reason needs to be pretty spelled out because we see some really awful reasons why grandparents have been restricted. So I think that would kind of undo the intent of the whole bill if that's allowed to stay stated like that. The court order authorizing grandparents or kinship custody or visitation also, in my humble opinion, needs to include the words requiring compliance, or else we go through the same situation that we do in custody where one doesn't want to relinquish the children, and then you have to file for contempt, wait for that hearing. If the original orders say that you're supposed to have the custody or visitation rights, that ought to be in it. Again, we're already putting out reasons why, you're protecting the child. You're not going to say there's no reason you could prohibit that, but the first judge ought to be hearing that. And so I really think that this double whammy of you get the court order after spending lots of time in court and lots of money on good legal advice, and then the person doesn't want to do it, so then you have to go back to court. That is a really wasteful process that's going on in family court all the time now. Let's change the wording, change the interpretation. Let's fix that so you don't have to file for contempt. And another problem with family court is that family court judges by RSA are supposed to be assigned to a family. But it's in circuit court, so you never know which judge you're going to get. So I think we ought to go back to the RSA, and once you have a family court judge, you keep the same one so you don't start fresh every time you go back to court.
Thank you, Mr. Chair, and thank you for taking my question. So the concerns that you just brought up and the suggestions to fix the bill, did you bring them up in the House?
No, I was unaware. I was unaware of it.
Okay, thank you.
Thank you.
Thank you, Representative. Are there any members of the public who are present who wish to testify that have not testified already? Seeing none, we'll...
That was a big wind-up with that thing.
That was a high reach. Seeing none, we will now close the public hearing on HB 486. Do we have a motion to go into executive session?
So moved.
Second.
All right. And just to remember, because there's three of us, if two of us were to meet, we would have a quorum, and unless it's a caucus, my friend from Manchester on my left, him and I wouldn't be able to talk outside this room, so everyone gets to just see how the sauce is made from scratch. So we're in an executive session. I think in respect to HB 204.
Yeah, I'd like to make a motion of ought to pass on HB 204.
Second.
As I look from my file, was that the one with the typo in it?
No.
No.
No. Is there any discussion on that? I think it's virtually identical to the bill we had last term.
Correct.
I know it was a House bill that we passed. I'm not sure what happened to it, but it didn't make it after we passed in the Senate. But anyway, so motions ought to pass. All in favor?
Aye.
Aye. All opposed? Ayes have it, 3-0.
I'll move consent.
I'll take it.
Senator Sullivan.
I second the move for consent.
All in favor?
Aye.
Aye. Any opposed? The ayes have it. All right, it's 204.
Yeah.
I think we can at least take up HB 213. That's relative to the wage garnishment for child support. Is that the one?
That's on the typo.
That is a typo.
Yeah.
So I would make a motion ought to pass with an amendment to change the word on line 5 from arraignment to arrangement.
I'll second that.
It's been seconded by Senator Long. So the motion is ought to pass, and you're offering a committee amendment. So we have to adopt the committee amendment. So those in favor of adopting the committee amendment that just changes one word, which we believe is a typographical error as confessed by the prime sponsor. So all those in favor?
Aye.
Aye. All opposed? The ayes have it, 3-0. So now it's ought to pass as amended. Any discussion?
No.
So all those in favor?
Aye.
Aye. All opposed? Ayes have it, 3-0.
Move to consent?
Is there a second?
Second. 213.
213, which is relative to wage garnishment for child support. It's on consent. And Senator Long, you want to take that out?
I could take it out, sure.
Do you want me to do the amendment, or would you like to? I do it. You do it. I love that. It's good to be
I told you,
isn't
he's,
it? Thank you.
he's on point. And it's his first year, too, and he's doing excellent.
Is doing excellent.
I think the other one, we can, at least this, I think we might be able to, HB 478, that's establishing a foster care oversight subcommittee within the Oversight Commission on Children's Services.
Yeah, that's, again, my only concern of that is,
It has no fiscal note, so we don't have to move on today. I know there's bills floating around in the other chamber that may remove that place from its existence, but that's not before us.
okay,
And I think for the sake of us, it's just the policy right now.
that's fine.
So in respect to the policy, is there any objections?
No.
No.
We need a motion, though.
So,
I'll move OTP on House Bill 478, is it?
I'll second.
Yeah.
so all those in favor of ought to pass?
Aye.
Aye. All opposed? The ayes have it, 3-0.
Make a motion for consent.
Second.
So, for consent, the ayes have it.
Yeah.
Senator Long,
I
you
can
want-
take it out, sure.
And then, just so we can discuss the other bills, I don't think we're gonna act on the rest of them today, but we're just gonna have a discussion. I think in respect to HB 243, that is relative to the penalty for false reports of suspected abuse and neglect.
Yeah.
So,
I would be okay with this,
It-
changing line 13 to knowingly, as you had suggested.
so I wrote it from scratch, so I'm not gonna, but I went to I don't have my computer with me to look up RSA 169-C to 39. My understanding from what the testimony was, and I'm sure they'll shake their head in that direction if I'm wrong, I think on page 2, lines 8 to 11, that might already exist. That has to do with someone who's a mandated reporter that doesn't report it. And I think that exists under a different RSA. So I don't think we need to put that in there again. If that was my understanding of the testimony. I haven't obviously referenced that, but we don't need to say it twice in the law if it's already in the law. It's just on another section. But if I'm wrong, then obviously that's different, right?
Yeah.
So what I looked at was,
So Senator, I think this is mostly existing law, and then we're just changing what's in it bold and highlighted, right? So it wouldn't be redundant, it's just this part is changing. These two sections are changing, I believe.
you are correct.
Oh.
All right, never mind then. So the only section is, well, it says new section under section C right on page 1, line 26. So I think that would fall into the new section.
Correct.
We'll double check that. I think we're on the same page. We don't get to say it twice. So I looked at, so the culpability RSA is 626:2. And if you take knowing, or knowingly, and my thought is referencing RSA 641:4, that would be the false information, or causing false information to be provided to a police department with the intention of them acting on that information. So whether it's the person complaining or they tell someone else, it's basically, and it's information, it's not a statement. This is, as it's written, it's the statement only, but I think, my understanding really, it's the information, whether you don't have to say anything, but you can put makeup on to make it look like you get what I'm saying? Like, it's really providing false information is what I thought the intent of this was, but a person is guilty of a misdemeanor if he or she knowingly provides or causes false information related to suspected child abuse or neglect as defined by RSA 169:3B report to the department. We'll clean that up, but that's basically the direction. I think if that at least operates in, I think, consistent with other laws, minus my own grammatical errors as I'm writing. I think that would cover that. Then, for the purposes of civil liability, you may want to just mirror that, because it's, under the civil liability, it says, a person harmed by the intentional submission of a false report of abuse and neglect. Again, I think that's worded different. I think that only applies to the person submitting it, as opposed to telling your friend and then your friend reporting it. So I think you want to just line those up, at least make it consistent. You would have to do that. And otherwise, I think that would solve most of that. When it said maliciously or with the intent to harm, I wasn't sure if that should be and or, but if we put knowingly, we wouldn't need to address that.
Right.
But I look at what this is trying to address, and a lot of people that were in support of it knew the people that were putting in false reports. This one, you still don't know who the person is. So I don't see where this helps.
I agree that, so, and a problem in I guess, in enforceability is you have to know who put the false report in. Even if it's not disclosed, if you report it to the police, then the police make the report, right? Although that's a separate charge altogether. You might be able to figure, I know it's not always disclosed, but you might be able you can often figure it out. But my thought is if there's an investigation thereafter, and you're going to be able to understand through that investigation, you might have a better idea what happened. But if it is an actual, comes out that it's false, I think that's when you would be able to discover that. I think the ones that get screened out, those are, I suppose, a technical violation of this, but I'm not sure if the tree falls and no one hears it, doesn't make a sound. It's going to be hard to
I don't
enforce it
think that this is perfect. I think that, but I don't think that there's an appetite to make it perfect right now. I think it's a step in the right direction. I think people might hesitate to do a false report if we have this in law, because there's always the concern that we will miss a child, right? So that's the concern on people that are opposing this. So I think it's a step in the right direction, and we have the opportunity to make it stronger down the road if it's not effective.
Well, keep in mind, in a criminal prosecution, your burden of proof is very high. So the prosecutor, for it to be prosecuted, just kind of like perjury, they have to really have a strong case that you knew this was false and did it anyway, basically under false pretenses, which is very hard to prove. But so it would have to really be, I think this would really come up mostly when it's the most blatant cases. It's not perfect, but I think we have some work to do on that, so I'll probably put something together for us to review next time we meet.
Sounds good.
But whether you support the underlying policy thereafter. But I don't think I'm making any major changes.
No, right.
With that, I think I'm just making it. At least I hope I'm making it.
Yeah.
Okay.
No,
That's the goal.
Yeah, this is specific to DCYF reports. But the changes that you're putting in there also addresses that.
Yeah.
Just while we're here, if there's any discussion on any of the, I wish the prime sponsor of HB 320 was available. I know he does practice in the family law field. He couldn't make it today, so but I would encourage anyone to reach out to him if any questions. But any issues on 486 to discuss? We're not going to exec 486 today, but I think
No, I thought.
I'm not very familiar with how that has been applied in the law, so I'm not.
Well, yeah, it
Other than
seems
what we heard today.
from what I heard is if you're not divorced, you don't have this right, grandparent visitation. That's what I heard is the issue. Once there's a divorce, then you could go for grandparents' visitation, and the judge would decide if you get them or not.
And just, I want to thank the families that came forward, because I know this was very difficult to talk about today. It's very painful for you all, so I just want to thank you for coming forward. When we're dealing with with people in addiction, often there isn't a divorce because one spouse disappears or one spouse, they're not able to get them into a mindset where they can comply or go through the procedures. So the families are sort of left in limbo. Right, so they'd be separated but not divorced, and they're just sort of left in limbo.
What I will say, this law and legislation aside, if the court is determining the best interest of the child, and a parent decides to, create some type of wall or division amongst the grandparents when there was a positive relationship, I mean, I think that would come out in just this one. It's up to the court to what they want to factor in. But to me, that's relevant whether the parent is acting in the best interest. And to me, I think we could address this in this bill, but I think either way, it's still something to always bring up because a parent not acting in the best interest, and just because there's a separation, they're all different circumstances. But it seems that I would hope the courts factor that into when they make custodial orders to not divide the family any further than it's already been. But we're not going to exec that today. Any other discussion?
No, well, the best case scenario is all the parties involved have the child's best interest, and it doesn't appear that that's the case,
It's an unfortunate reality.
The mom is probably upset with the ex,
Yeah.
and taking it out on the parents,
Yeah.
the ex's parents,
takes it out on
which
the
is
kids.
unfortunately, the kids lose out. I mean, the more kids love, the more adults love the children, the better off the children will be, right?
Yeah.
I don't know about anyone else. It's also free babysitters in my house.
Yeah, there you go.
But I think the Honorable Betty Gay made up a good point that requiring compliance, if we don't require compliance, it sort of doesn't do anything.
Right.
So I think we should add that in there.
Yeah, I suppose we can consider, I mean,
Oh,
there's
I
the
see.
contempt provision. You
Yeah.
file for contempt.
Yeah.
I mean, the remedy is essentially, they can, I guess, give you back at the time that you missed and some, but I'm not, what else would the remedy be beyond that?
Yeah, you're not about to take the kids away from the parent, so, yeah, you're right.
They're in contempt, but I'm just saying, so in contempt, there can be legal fees. As a remedy, they can, if you missed, let's say, 3 days of parent time, grandparenting time, they can give you 3 days on top of whatever it is, but other than that, what else would the remedy be? I suppose it's criminal contempt, it's, again, rarely prosecuted. Heard that a lot today, but what else could we do? I think having the police unilaterally just get involved in enforcement, that puts the police in a difficult spot, because not every order I've seen is actually as clear as you would think. When it comes to probate and family court.
Yeah, it puts the kids in a precarious position too, if there's a police that has to come to my mom so that I can see my grandma. What's up? That's, that's traumatizing to the child.
It can be. I'm just saying, like, for the police to have to interpret the order, without.
Oh, I know what you mean.
Sometimes it's very obvious what the order says and it's non-compliant.
Right.
But let's just simple meeting, pick up, drop off is, in front of the State House. Parent doesn't show up. Clearly they're in violation of the order, but if you want the parent now to go with the police, in that case, it's very obvious, but it's like, is that, there can be something that are less obvious. I don't know. I'm not taking a position either way. Just something to think about. We'll be back.
Yeah.
Yep. us a chance to actually research other states, how they do it too. So.
I was hoping to be back next Thursday to see how it works.
Busy day next Thursday. See, he says no. The boss says no.
All right, well, is there a motion to come out of executive session?
So moved.
Second.
All in favor?
Aye.
All opposed? The ayes have it. And we are adjourned. We need a motion to adjourn?
Make a motion to adjourn.
Second.
All in favor?
Aye.
All right, ayes have it. We are adjourned.
Which bill was that Michelle just voted on?
We didn't vote on it. We voted to come out of executive session because we're stuck in there. I once adjourned about being in executive session and they were not happy. Not in, when I was in the other chamber.
Which ones we just passed to go in consent?
Yeah.
Oh.
I wrote those two down.
Oh, 204, 213, and 478. So relative to the criteria of reporting child support delinquency to federal agencies relative to wage garnishment for child support,